And we'll give it back to Regina. I'm sorry, it's Aaron. We'll give it to Aaron.
All right, so I will be presenting both the secretaries and the fall meeting minutes and the treasurer's report. Bear with me, I've done this successfully once. I'm going to be clicking around and sharing my screen and picking the right one. Oh, come on. And let's go ahead and share the minutes. There we go. Can everybody see that okay?
Yes. Yes.
Okay. So these are the meeting minutes from the very long ago NOTSL fall program. I would like to ask, this is going to be interesting because I just uncovered my notes that I'm supposed to ask. Can I have somebody to approve the minutes? If you could just type your name in the chat.
I'd like to make a motion to approve the meeting minutes of the fall 2019 program.
Yes, and then can I have a second to approve the minutes of the NOTSL fall 2019 program? Okay.
So we have a second.
And my chat disappeared, so am I good to go for the next?
Yes, you have a second by Ann.
Okay. So here's the current treasurer's report. Normally presented by Laura. You also received this. There should be a link in your agenda if you want to take a closer look. But can I get a someone to motion to approve the NOTSL Spring 2019 meeting treasurer's report? And can I get a second?
So Nate Freilich, I'd like to put forward a motion to approve the Northern Ohio Technical Services Library Treasurer's Report for spring 2019.
Okay. And can I get a second? I can't see my chat, so.
Again, second by Ann.
Okay, awesome. And so finally, I think next is the attendee appreciation drawing, which Laura figured out. So everybody can see, this is my randomized picker, and this is the list of everybody. Enter all the names, pick a random name. Let's see who wins. Da, da, da. Kelly Bay is the first one. And we're going to do two.
Erin, do you want to tell them what they're winning?
Oh, sorry. You are winning a free registration for the next few, whatever NOTSL meeting strikes your fancy that you want to come to. So, and the second one is Kelly Rowan. So basically, we will write your names down. And so when you register, you can either note in the registration or something like that, that you want a free registration, or we'll remember your name and give it to you. So, and I think the most painful part of the meeting is over.
Well, thank you. Thank you, Erin. We appreciate it. And I hope all the congratulations to the winners. Yes. And this is normally the portion where we do elections. If this were a normal year, but 2020 has been anything but normal. So the board members have decided to hang in there for an extra year. And we plan on holding our next elections in the spring of 2022. We all deeply appreciate everyone willing to hang in there. And additionally, I would like to ask that if anyone is interested in applying for an open position, during the spring of 2022 that you might consider running. And if you are interested, just add it to your evaluation form, and we'll be sure to contact you and let you know what's available and what to expect. Now, as a reminder, please be advised that we are now recording the presentation. And before I begin, I'd like to introduce and welcome our speakers, Cindy Kristoff and Virginia Dressler. Cindy Kristoff manages digital projects and institutional repository initiatives, provides copyright clearance services for faculty and students, and conducts instructional sessions on copyright, fair use, open access, and Creative Commons licenses at Kent State University libraries. In addition, she coordinates affordable learning initiatives for the libraries and serves as Kent State's Ohio Link ETD administrator, and she is University Libraries Faculty Senate representative. She holds a BA in English Literature from The Ohio State University and an MLS from Kent State University. Her partner, Virginia Dressler, currently serves as the Digital Projects Librarian at Kent State University Libraries. Her specialty areas are project management of digital projects and reformatting of analog collections for open digital collections, including overseeing the Daily Kent Stater Digital Archive Project, the daily student newspaper, and working with the university's unique collection. And she holds an MLIS from Kent State University and an MA in Art Gallery and Museum Studies from the University of Leeds. The first session, Copyright Basics and Creative Considerations, will be presented by Cindy Kristoff. Nathan and Chloe will insert poll questions and moderate Q&A at the end of the session. With that, I give you Cindy.
Thank you, Regina. I'm so excited to be here. Thanks to everyone for having me here today. I love to talk about copyright. I don't know how many of you do copyright in your everyday jobs or how familiar you are with it, but what I'm hoping to do today is just provide some very basics and provide also just a couple of interesting anecdotes and stories about copyright. Margaret and I have talked about this, but it's very hard to pin down something like copy wrongs and pin down something like rules when it comes to copyright. The standard answer when you get asked a copyright question is it depends. And it depends comes up quite a bit because while there are, there are laws rather than rules, the laws are open to interpretation, and that's what the courts have been doing for many, many years. So it does depend, and you will see the flexibility in the law as we go through this and kind of our examples. And, I'm not an attorney, so I can't really make those judgments for other people. All I can do is, control what I have in my purview, which is, the digital projects and the institutional repository, which I oversee. But, I can't give advice. I can't tell people, oh, here's what you need to do. Necessarily, I can say, here's what we did, and here's how we thought about it. Here's how we thought it through. And this is what we decided. So the only rule is it depends. And so we'll get to a lot of that today. Again, I'm going to try to move my slides forward here. Copyright basics and Creative Commons. Again, I'm not a lawyer. My job has always involved copyright for some reason, though. It kept rearing its ugly head. And I started off in interlibrary loan or resource sharing many, many years ago in the early 90s. And there did seem to be real rules back then. We abided by the COM2 guidelines as if they were law. And lately that's being questioned, which is a very welcoming thing. But I really resented copyright for a long time. I thought, gosh, this is such a gray area. It's difficult. Oh no, here this comes again. And I don't know where to go with this question. I kept getting questions. And the more I got questions, the more I decided, well, I better learn about this. So I learned about it. And here I landed today. I didn't expect to be here. Probably if I had expected, I might have gone to law school, but I never did. And I will say that I work very, very closely with the Kent State University Council. So I have a good relationship with the attorneys there. And anytime I run into a question that I don't feel comfortable with, I go to them. If they run into something that involves fair use or something that has to do with the use of copyrighted materials in educational settings, they come to me. It's interesting, the relationship. They get a lot of takedown notices and that sort of thing for the university. And, so that's what they do. And basically I focus on education. So that's a little bit about what I do. I think copyright is a lot of fun, and this is a great example of why copyright is fun. And this happens to be a clip or rather a photo from the 2013 Dragon Con, which took place in Atlanta, Georgia. So this is a little bit old, but I think this is one of the most fun examples possible. The carpet there at the Marriott Marquis Hotel is outrageous, as you can see. So what the cosplayers wanted to do was put together outfits that camouflage them in this environment. And this was a lot of fun for everybody at the conference. Volpin Props was in charge of putting this together, and they do a lot of props that are based on video games and that sort of thing. What they did here was they took this pattern and copied it, and they made it available for sale on spoonflower.com. And I don't know how many of you do crafts or sewing or even create your own patterns, but spoonflower.com, remember that if you were interested in buying cloth with hand-drawn patterns or wrapping paper. They do a lot of fun stuff like that. Anyway, they made this pattern available for sale there, and Kuristan Carpets noticed this, and they said, oh, no, you don't. Don't you dare put our pattern for sale. This is a copyrighted pattern. Someone created this. They were very proud of this. And so basically they sent Volpin Props what's called a cease and desist order. And Volpin Props decided not to fight it. They giggled a little. Someone said, oh, I can't believe anybody would admit to have come up with that outrageous pattern. But, this really was somebody's intellectual property. And Volpin Props said, no problem. We're just going to take it down. We're not going to fight this. We're not going to take it to court. We respect your intellectual property rights. But it was fun. It was fun for a moment in time, and I still think it's fun, so I show it as an example. This is another way that copyright can be interesting too. I have there's a man who I went to high school with, and he was Bobby Lee was the best artist in our class. He came to us in junior high, and he went on to create Methane Studios, which does a lot of promotion for musical groups such as Dave Matthews and other things I haven't heard of because I'm no longer young. But one of his most famous patterns is this kind of neon Atlanta airport sign and ATL. And what happened to him one day is he walked into a Target and he saw ATL was co-opted by Target. And they're selling a t-shirt with basically what's my design altered maybe a little bit. And he's like, that's not cool. So he consulted with an intellectual property lawyer, and you can make it big. You can be like Bobby Lee. You can own Methane Studios, and he's tremendously successful, but maybe not on the range that Target is. And so I think what happened is they settled out of court. Bobby isn't very forthcoming about what happened, but this really made him mad. And, I told him I use this example all the time because it's such a good one. You can see where they did copy. It's this, what they call a striking similarity in court cases, where, you know, really they took his design and basically copied the idea of it and, you know, tried to sell it. And so that's what happens, but this keeps things interesting. And this is the first time that I think copyright got really personal for me. But I also use it as an example in classes when I teach our visual or graphics courses. This is the kind of thing that can happen. And be careful when you create a logo and watch out for some of these kinds of things. Intellectual property is an umbrella term, and that term kind of covers patents and trademarks and trade secrets as well. So it's not just copyright, but these are all clumped under intellectual property. Patents were really kind of the idea came from, and the idea for copyright too came from the Constitution. This is all set forth in the Constitution, where the framers wanted to give Congress the power to promote the progress of science and the useful arts. So science became copyright. The useful arts really became inventions by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. And this was to provide an incentive for people to keep creating. And when I get stuck, sometimes I think about the primary purpose, and, you know, we'll kind of get to some of those cases later. But copyright is federal law. It's Title 17 of the US Code. It does grant a set of exclusive rights to copyright owners, and those are for limited periods of time. We'll see that limited can be a very long time as we go along. These exclusive rights are balanced out with exceptions, and those exceptions are where we start saying it depends a lot. Kyle Courtney calls a lot of those our librarian superpowers, which I think is a very exciting term for it. We do have some superpowers. So before, you know, I go on, I wanted to say, if you do want to take a look at the law, the text of the law is at copyright.gov. It's but I really make use of the Legal Information Institute at Cornell a lot. I really like the readability and the layout of the way they present the law, and they present notes about the law. I don't mind the ads for lawyers off to the right-hand side, and I do donate to them through PayPal a couple times a year. They're good folks. Patents and trademarks are under a different division. There's the U.S. Patent and Trademark Office, whereas the U.S. Copyright Office reports up under the Library of Congress. So, you know, no wonder librarians get, you know, stuck with copyright questions. I actually grew to enjoy copyright despite my early resentment. Patents and trademarks are under their own office. And for a while, I think they were kind of thinking about throwing copyrights in here too. I hope that doesn't happen. I also hope the Copyright Office doesn't go under the U.S. Department of Commerce. That's another thing that comes up every once in a while. Patents have much shorter terms, 20 years. And, you know, actually calculating a patent term is a lot more complex than just, oh, I invented it 20 years from now. You know, it depends on some other things, paperwork and filing and that kind of thing. There are 3 different types of patents: utility for creating a new process or a machine, design patent for an ornamental design, and there's actually a plant patent for grain growing things. Trademarks are another fork in that. There's the registered trademark, where you complete the paperwork and you have the little R with the circle. Then there's the unregistered trademark, which is TM, and that's basically, if you're using it, business law kind of supports your use of it. As long as you keep using it, you can keep using it. And as long as you keep filling out the paperwork, you keep filling out the paperwork. But those terms, so they don't really run out unless you quit using it. So that's kind of a different animal. I don't do a whole lot with patents and trademarks. I do joint workshops with University Council about patents and trademarks, and they talk about that. But here's just an example of what can be patented and how that works. So glaucoma medication was found to make everybody's eyelashes glamorous at one point. So the manufacturers decided, hey, let's take this generic drug, which helps people with glaucoma, and market it as Latisse for eyelashes. And we'll market it that way, we'll promote it that way, and get some more business. So you're allowed to do that. You're allowed to take a previously generic drug. make it for a different purpose and then market it that way, and then the patent runs out. So as of late 2016, Latisse is generic again. So, you know, they got their money out of it for a while, and I think, you know, people try to get more glamorous eyelashes, and hopefully it didn't irritate too many people's eyes. But that's how a patent works, roughly speaking. And trademarks, these are trademarks that you've seen everywhere. They are everywhere. You can look for a trademark. I think a lot of our VCD, visual design and communications and graphics students, they will probably grow up to try to invent a trademark or a logo that they, you know, put some intellectual property on. And it's a tricky process. They learn that in class. I have never taken such a class. I can't imagine having to do that. So anyway, copyrights, we talked about, you know, the difference between copyrights and patents, but what can be copyrighted? Well, copyright protects original works of authorship. They don't have to be terribly original. There are some very factual sentences that maybe can't be copyrighted, but copyright generally protects original works of authorship. They're fixed in the tangible medium of expression. So if you've typed something out and it's original and you hit the save key, that's your copyright. You don't need to get it. You have it right as soon as you hit that save key, and you own the copyright to all the next editions of things. So if you alter it a little bit, or, you know, create several different versions, you own the copyright to all of those, and copyright protects that without you having to register. What cannot be copyrighted, and this is probably a little bit more illustrative of what can be copyrighted. Things that are not fixed can't be copyrighted. So if you know, do a little dance in a nightclub and nobody's recording it, then you haven't notated it, it's not copyrightable. Really ephemeral or transitory items like maybe soap bubbles that you blow in your backyard can't be copyrighted. But if you take a picture of that soap bubble, yes, it can be copyrighted because the photo is copyrightable. You cannot copyright an idea. So when someone says to you, oh, that's a great idea, you should copyright it. No, you have to get the expression of it down in some fixed and tangible format before you can copyright it. Facts such as addresses and phone numbers, weights and measures, recipes, all of these things are not copyrightable. Names are not copyrightable. However, sometimes you can trademark a name or a title or data. Data can be copyrighted, and numerical data generally isn't copyrighted. But if you've got data in the format that is copyrightable, such as a series of photographs, and that serves as your data, that is copyrightable. So this gets very complex. Data can be stored in secret. You don't have to share your data. You can license out your data. That's what vendors do. We all know that. So data is a little bit tricky with that. Processes, you know, I talked about recipes not being copyrightable, but any kind of process to create, for example, Latisse, certainly that's a patented process. So intellectual property gets a little bit tricky here. Getting copyright, like I said, you don't have to get it. You have it once you've expressed that idea in a fixed and tangible medium. You can mark it with the copyright sign, the circle with your year, and then followed by your name. And that sends a signal to whoever's reading it. I copyrighted this idea. You can register your work for a fee through the US Copyright Office. And this is it's a little bit expensive. I think it's about $55 for a basic filing, maybe a little bit less if it's really basic. But it looks like a tax form at first glance. So sometimes I try to help people through that, you know, oh, what does this term mean? Or what do they mean when they talk about that? So I talk people through it, and, you know, people have to enter their own credit card information at the end. It takes about 6 to 8 weeks, depending on how busy the Copyright Office is. But most filings are done electronically now, so that's a good thing. I talked about exclusive rights, how copyright grants those exclusive rights to the copyright owner for a limited period of time. And these are the exclusive rights. So you've got this limited monopoly if you're a copyright holder. And if you're a copyright holder, you are not necessarily the creator. It could be that the creator signs over the copyrights to either a publisher or an institution or something such as that for things to be distributed. But the copyright owner has these rights to make copies. You're allowed to make a copy. You're allowed to distribute that copyright publicly and create derivative works. My favorite example of a derivative work is a Happy Meal toy. Happy Meal toys are generally derivative works, little toys based on a video game or a popular movie or a cartoon or something like that. And you can take a look at the wrapper that covers the Happy Meal toy, and you can see that it's covered with intellectual property warnings, as well as the warning about, this plastic is not a toy. You have the right to publicly display the work if it's a painting or a sculpture, or publicly perform the work, such as a play or a song, and public performance by means of digital audio transmission. So when digital audio transmission happened, they added that as an exclusive right. But there are all kinds of exceptions to these exclusive rights too, to allow us to function. I wanted to mention moral rights a little bit because this doesn't play into the game a lot with US law, but it does with foreign law, but it does in a particular part of US law, and that's this Visual Rights Act of 1990, or VERA. And this is a section 106A, which you have the right as an artist to not have your art corrupted or damage due to neglect. Even if you've signed over the copyright to the institution, you have that right of expression as an artist, this kind of concept of paternity or integrity. So like, I am the creator of this, I created this, and it represents me. So you've got this integrity that comes out in there. And there was an interesting case. This is a really good write-up in the Des Moines Register about how the Visual Rights Act works in the United States. But essentially, this artist created a sculpture for this college, and the college said, well, we're changing it a little bit and we're putting plants in it. And the artist hated that, and she's like, no, this doesn't represent me anymore, look at the difference. And so I put the pictures up and you can kind of see the difference. We're not going to get into a lot of these cases in a lot of depth, but I want you to be able to go and look and see what artists take a look at, what cases are composed of. So I put these examples in here that when you get the slides, and if you're interested in going back later, you can read about it. So that's one example of moral rights. But these are the exceptions to those exclusive rights. Fair use is the most famous exception. People say, well, I'd like to invoke fair use. Well, if you invoke fair use, it's my feeling that you should be able to say why this is a fair use and be able to articulate why you think it is. You can't just say, oh, it's for educational use, therefore it's fair use. A lot of people are very flippant and they say that, and it doesn't necessarily work that way. There are other factors to consider. So we'll go over that. Reproduction by libraries and archives, but not museums, is section 108. We'll talk a little bit about 108 because 108 allows libraries to do a lot of great stuff, not just with interlibrary loan or not just with your patrons making copies for themselves, but also for digital projects. So that's been a fun one to explore. The right of first sale, which is embedded in section 109, is what allows us to loan books and videos and any other kind of object. We're allowed to do that because of section 109. Again, 109 plays into what we're allowed to do with a digital archive. So we'll go over that a little bit. There are exceptions for certain performances and displays, such as your professor is allowed to show a movie in your class, and that's section 110. Section 110 gets a little bit mucked up when we talk about showing a film in an online classroom. That's where it gets a little bit more complex because the Teach Act isn't very friendly. So a lot of times what happens when the law does not allow us to do what we need to do, we go back to fair use, section 107. So we'll talk about the fair use savings clause a little bit. There are reproductions for people who are print disabled in Section 121 of the Chafee Act, and that allows people greater access to copyrighted works. So how do works get into the public domain? We talk about the public domain because it's so easy. If something is in the public domain, it means anybody can use it. It doesn't mean they can take credit for it. You can't say it's by you, because that would be plagiarism, right? Which is not a legal term, but it's a moral term, and a term that's used a lot in education. But things get into the public domain in a couple of different ways. They're either created by the US government in the form of a US government employee creating their own work on behalf of the US government. So it's a work for hire. That's Section 105 of the US copyright law. Sometimes things are placed into the public domain by their creators, and we have a Creative Commons symbol for that now, the CC0. Sometimes they age into the public domain. So this date keeps moving up every new year. And that's what I look forward to on New Year's Day, is that one more year will move into the public domain, unless Congress decides to enact a law to stop that from happening. So this year it was anything before 1926. So things things age into the public domain. Copyrights last the life of the author plus 70 years. And that's just a really basic kind of overgeneralization of how the law is now. Works made for hire last a little bit longer. So if you go to work for a company, then you write something up for them, that copyright is a little bit longer. But there were works published between 1924, of course now it's 1925, and 1963 with a copyright statement, but never had their copyrights renewed. And this is some 80% of these copyrighted works that were just never re-registered. Some of them weren't published with a copyright statement to begin with. So the copyright statement being the copyright, 1934, and then a name by Joe Smith or whatnot. If they weren't published without that, or if they were not renewed, then after 28 years, then these things fell into the public domain. So this is a kind of a basic website that I've pointed at. Please look at it on your own time. It's fascinating. There's a little blog that posts surprise things in the public domain every day or every week or something, so you can kind of see what's in the public domain. Pretty interesting stuff there that really opens up a lot of opportunities, I think, for libraries and for digital preservation. So here are the things that are born into the public domain. So Uncle Sam was a creation of the government in World War I recruiting, and we see Uncle Sam everywhere, sometimes with red stripes on the top of his hat, but this is kind of this public domain thing. I guess it's time for our first quiz. And our first quiz is, if somebody like Uncle Sam was created by the US government and placed into the public domain, then other things such as characters such as Smokey Bear must be as well. True or false? We'll give you some time to answer that. Created by the government, right? These little characters. And we've got some votes coming in here. True or false on Smokey Bear? Only you can prevent forest fires, Smokey Bear, which I guess is controversial now because he might be giving people the wrong idea, because some forest fires are good and should not be necessarily prevented. So we've got 73% voted. I don't know if we want to keep, as long as I keep seeing these numbers move, I'm going to keep this poll going. But I think probably they've settled down by now, so we will end this polling. And some of you, 21% said it was true, 82% said it was false. Yes, it is false. There was a Smokey the Bear Act that was enacted in Congress to keep Smokey Bear from being used just randomly like Uncle Sam is, or, being used by anybody. They wanted to kind of protect that. So the Congress can draw up special laws to really put the lid on that and kind of keep it like a private industry would. So that's what happened with Smokey Bear, and you can look that up, and I think it's a great deal of fun, and I was fascinated when I first discovered that. So I'm gonna stop sharing the results. Congratulations to those of you who got that right. There is no prize for this. Maybe a couple of the lucky Kellys will win, but anyway. I should go on and say the bit about aging into the public domain, this life of the author plus 70 years. That's a really long time. We're in grandchildren and great-grandchildren territory where your heirs can inherit those copyrights if you don't sign them over in your will to some other party. And then again, for anything that's anonymous and pseudonymous, can't say that very well, works made for hire and works that are held by, the copyright is held by the corporation. There is the famous public domain chart created by Peter Hurdle. Peter Hurdle has done a lot of great work with copyright. He's not a lawyer either. So hooray for us non-lawyer kind of people who love this realm. The public domain chart is updated every year. This is a reference. Peter has always said, you can start here, please don't end here, because there are other things to check for public domain. You can check for, you need to check the copyright records to see if something was re-registered, renewed for copyright back when you can renew things for copyright. So this isn't, you need to check the work itself to see if the copyright sign is on there. It's worth noting that unpublished works are given a lot more copyright protection under US law. So never published, never registered works have a lot of, I think, commercial potential there. So the law wants to grant them that, that ability. So pay careful attention, but this is one tool you can use. This was placed into the public domain. The ever-present peace sign, you see it everywhere, a lot of times on girls' clothing. But you used to see it in jewelry, and you still do see it there in a variety of settings, and it's one of those things that kind of fades in and out of fashion. But this was created in the 50s by the Coalition for Nuclear Disarmament. It's actually the semaphore code for nuclear disarmament laid on top of each other, the flag symbols. Anyway, there's a story of this symbol and how the creator wanted people to use it, but also wanted people who used it to contribute to the peace endeavors. I'm not sure everybody who uses it does that, but this is what happens when you put something into the public domain on your own. The Mona Lisa is in the public domain, although the Louvre actually licenses out pictures, copies of this picture. The image itself, one that is not licensed out by the Louvre, is in the public domain. So our museum sciences program that we had for a while in the information school at Kent State did this fascinating stuff with the Mona Lisa, imposing different faces on her and putting her in different settings and that sort of thing. And you see, like now you see like the Mona Lisa getting vaccinated. You're allowed to do these things because, the Mona Lisa is hundreds of years old and in the public domain. My favorite is the one with the ginger cat where she's holding on to the cat. The cat doesn't particularly look like he wants to be there, but it's adorable. So shifting a little bit to the first sale doctrine, Section 109 lets us lend out books. It's also what lets us sell books either in the libraries or try to sell them at a garage sale. We can use them in any way we want, including destroying them. This applies to materials that are owned rather than licensed. So anything that you licensed, you can't necessarily do this with. You can't give your Amazon Kindle books to your heirs, at least not as how the law stands now. So license is more akin to a rental in that they control what you do with it afterward. First sale doctrine does not control what you do with it afterward. This is a concept that's hard to get across sometimes to instructors who want to, well, first they wanted to take all their VHS tapes and create DVDs, and now they want to take their DVDs and stream them online. And they say, well, I already bought the intellectual content. I shouldn't have to license it again. Well, you kind of do, because we own the object when we buy an object, but we don't own the creative content within. So you can create a service desk, or the School of Fashion actually had a counter made out of some of our discarded cereals for a while. What you can't do is pluck one of those volumes out of there necessarily and scan the inside of it. Maybe you can, maybe it's in the public domain, maybe you have permission to do that, but you can't just assume you can do that because you own the book. That's not how it works. And so that's the best way I could think of to explain that difference. Anyway, reproductions by libraries and archives. This is section 108 of the copyright law. And around the same time those big photocopy machines came into use, you started to have the copyright law. The Copyright Act of 1976 was being worked on because, you know, Congress knew it needed to do something. And now you've got a copy machine in the form of like a phone, right? All you need to do is take a picture. So this kind of harkens back, because originally you were allowed to take photographs of library materials, and you know, now you've got a photograph taking machine again. It's not a big copyright or photocopy machine. But they were very concerned about the impact that this machine would have on libraries and on copyrights. I think publishers were very afraid everything was going to get copied. They still fear that. So, you know, again, it's not just photocopiers now, but it's scanners and 3D printing machines and all these types of machines that we have now in our libraries that maybe Section 108 doesn't necessarily address and doesn't need to. I really do believe that the people who wrote Section 108 tried to be as careful with it to make it technology neutral as they could, but nobody has a crystal ball and it's very hard to see into the future. But 108 allows us to do things in the library that maybe we would not otherwise be allowed to do. And this is a very brief outline of what's in 108. This is vastly oversimplified and it's really a lot more complex than this, but it's not that much more complex than this. And if you're working with any kind of copying, if you've got machines in the library, if you've got a 3D printer, or if you're working in digital projects, you know, these are the kinds of things you need to pay attention to. If you're working in interlibrary loan, you need to know about this. So Section 108 is filled with these abilities for libraries and archives to make copies. And there are certain exceptions. So this is the kind of thing where you have to have reasonable signage next to your photocopy machines. You have to have a particular set of language that goes along with order forms. By law, your library can't even use Section 108 unless you're open to the public. If you're a special library, you need to be open to research who are interested in the materials you have within. Otherwise, you can't make use of Section 108. Can you make use of Section 107? Sure, but these exceptions to 108 don't necessarily apply to you. Your reproduction and your distribution must be without profit. If you're starting to make money on it, that's getting out of the realm of Section 108, and you need to cover copyrights in another way. The copyright needs to become the property of the user. You hear this all the time. A lot of times when I supervised interlibrary loan, students would ask, well, do we hang on to these articles that we scan? Because look, we're making copies and we don't want to make copies again. Well, no, you can't. The copy has to become the property of the user. Plus, if we were to hang on to those scans, how would we index them and later access them? The library has had no notice that the copy will be used for any purpose other than private study, scholarship, or research. So if your patron starts talking too much, you quit listening and walk away. You don't want to know that. You don't want to be monitoring your copy machines for what patrons are doing. That's not your job. You're displaying this sign saying, you know, materials may be protected by U.S. copyright law on your machines, and you have that notice warning, and then you leave them alone. That's part of the agreement with 108. The rights to make copies, of course, extend to these isolated and unrelated reproduction. Let's say you get a couple requests for single material over and over. Well, that's okay if it comes in and you make a copy. It doesn't really matter. But if you're working in interlibrary loan and you see the same set of students make the same request for the same material over and over, that probably is your signal that it needs to go to course reserves, right? Because these students are looking for a copy that can be shared by the whole class. You are not allowed to engage in this systematic reproduction or distribution as a library. So you have to watch out for things like that. But this allows interlibrary loan arrangements. And even in the cases where your interlibrary loan is of an entire piece, if you cannot find a copy on the market for a reasonable price, and of course the market doesn't define reasonably, libraries are allowed to make entire copies of works and send them to people. So that's something you need to read about in 108 if that's what you're doing. This is your big notice warning. This is the kind of thing that you will see on an interlibrary loan form and you have to agree to. Does anybody read it? Probably not, but supposedly they are supposed to have read it. You can't make someone read anything. But this notice warning comes from the Code of Federal Regulations, and people who have 3D printers in their libraries, there's a little bit of an adaptation that I think it was Tom Lipinski created that can be used as a notice warning for that sort of thing. So just a little bit of an adaptation, but this is from the Code of Federal Regulations. So I guess it's adapted every once in a while or, edited. By law, can your library or archive make use of Section 108? And Jenny and I will be talking about this later on today, but this Section 108H that allows us to make copies of things that are in the last 20 years of their copyright terms. So even if something has not fallen into the public domain, those things that are in their last terms, they might be in the public domain, but even if they're not, we may be able to make copies of them as long as they're not being exploited commercially at the current time, as long as they're not available at a reasonable price. So the library can take a look and see, can I build a digital collection around this? So last 20 projects have been talked about. Basically, the Internet Archive is partly working off of this principle. I've put a little link to that there. So that's an option. And now we will take a look at fair use. So this is the most famous of those exceptions. And there are 4 factors to fair use: purpose and character of use, the nature of the work that you're trying to reproduce, how much are you trying to reproduce, and the effect of the use on the market. And of course, being in a capitalist society, that's a really important thing. But also purpose and character is important too. And what I'm going to do is talk about purpose and character a little bit first. If your use is educational or nonprofit, it tends to side more on the side of fair use. If it's a parody, that's really good fair use. That's good stuff here. News reporting, small quotes for book reviews, anything like that. If you're reporting on something in the news, you want to make a short, quote, you're allowed to do that by law. Opposing fair use tends to be commercial activity or entertainment. Of course, bad faith behavior is, it's bad faith behavior, right? Or if you're denying credit to the original creator, that's really the intersection of plagiarism and copyright, where plagiarism is not a legal term, but you're trying to pass off something as your own and it's not. Well, that's part of that's part of what opposes fair use. But not always. See how it depends. These are rules, these are laws, but it depends. So I'm going to take a break for a second and we're going to have our second quiz. This is a multiple choice quiz. And I want to find out how many of you know who these guys are. Can anyone identify this American hip hop group? And I just love this genre. And I remember in junior high dances when, this hip hop first started coming out, it was just such a cool thing. And of course, the art form has really progressed. But this is really this is a kind of a breakthrough moment in copyright with this group. And so I'll give you a couple more seconds. I still see the numbers changing a little bit. I see some of you probably changing your answers, but you know what's funny about this is if you ask, like I present to classes a lot to undergraduate students, and this group might as well be, I don't know, the Glenn Miller Orchestra. What the Glenn Miller Orchestra is to me, that's how long ago it was. But I'm going to end the polling at this point, and I see most of you got it right. I love Run DMC and I love the Sugar Hill Gang. The Grandmaster Flash is a classic, but this is actually Two Live Crew. And they really played an important part in what we look to now in fair use is called transformative use. So I'm going to go on to the next slide at this point. This is Two Live Crew. What Two Live Crew did in the early 90s is they asked the estate of Roy Orbison, can we use Pretty Woman? We want to sample this. We want to change the lyrics up a little bit, and we want to have our own interpretation, our own spin on it. And Roy Orbison's estate said, nope. But Two Live Crew went ahead and did it anyway. And this all went all the way to the Supreme Court. And really, if you compare the lyrics between Pretty Woman and Two Live Crew's lyrics are really raunchy, really forward. It's not, they're not like nice. It really takes the Pretty Woman song and turns it on its head. And Justice David Souter called this transformative fair use, wherein you alter the original work with new expression, new meaning, or a new message. And the difference between Pretty Woman and Two Live Crew's Pretty Woman is huge. It's really an altered message if you go and you look at it. Those lyrics are pretty raunchy and it's great. But this really launched this whole idea of this new expression, meaning, or message. And when I took Copyright X, which is lectured by William Fisher, he had a really good kind of four-pronged meaning of transformative use. It's creative. There are physical modifications to the work. It's socially beneficial. It sends a message. And it's used for a different purpose. And parody, which, this is, parody fits all of these. Parody is intended to send a message. And so you have this for-profit use that ended up being fair use. So you can't always say something is going to be something based on whether it's, commercial or non-commercial. So there you have it. The nature of the copyrighted work. And again, this factor becomes a little bit less important in some cases. Certainly it was less important in Two Live Crew. So you have these things, this favored fair use, where if you've got something that's factual or nonfiction, versus something that's artistic, or if you've got words or song lyrics on, for example, a bookmark you're selling, or a t-shirt you're selling, or even distributing for free. The copyright owner may not want that to happen. So cease and desist orders come through with things like that, even things that are used for nonprofit purposes, because of factor 2. This is a really good example of factor 2 in action. This is a case, this actually is a photograph of the Mifflin Street Block Party. This is a University of Wisconsin block party that occurs every spring, and it's very popular with students, as you can imagine. So years ago, a certain Paul Soglin attended this party. There he is in the crowd, and you can't see him. But in 2012, he became the mayor of Madison, Wisconsin, and he's like, this party is too much. We're going to shut it down. It costs us in police. We have to repair the damage afterwards. And all the students said, boo, we don't want that to happen. So what they did was they took this photograph of Paul Soglin, and a t-shirt shop, a little mom and pop called Scotty Nation. Get it? Wisconsin Scotty Nation. They sold 54 t-shirts in protest of this mayor wanting to put the kibosh on this block party, and they sold them. This was a Madison, Wisconsin photographer called Michael Keenitz, and the students took this, basically downloaded it from the city of Madison's website at the time. So this became the court case of Keenitz, which is the photographer's name, versus Scotty Nation, which is the t-shirt company that created these, putting the image from the mayor's website onto this t-shirt. Sorry for partying. I would pay good money to have one of these t-shirts. I really would. If anyone's got one, man, I don't know how much money, but I would have to think about it a lot. But the Seventh Circuit Court of Appeals said, no, this is fair use, because the t-shirt was not a substitute for the original photograph. You weren't, in other words, you weren't going to take this photograph and use that in place of the original, because not much of the guy's face remained, just this kind of Cheshire cat smile sort of image that remains. Plus, it was a fair use because it was a First Amendment protest. These students were protesting the abolishment of this party. So it's a form of political commentary, not really for profit, even though they did sell 54 of them. So there you have it, Keenitz versus Scotty Nation. So the third factor, the amount and substantiality of the portion that gets used. You know that short quotes are fair use. You should also know that publishers will not generally print a quote that's too long. They want permission for that. And a lot of it is because of this case. But this case was actually a short quote. So opposing the idea of fair use is this large portion or the whole work used, but that's not always the case either. Sometimes you need to have that whole portion to get the educational point across. So you find that in classes, you can't just use a small portion, you need to use the whole portion. So this plays a part, but there's a very famous case here. There are a couple of cases here where actually websites used what's called thumbnails, or very poor quality, not poor quality, but low resolution images that cannot really be used to replace the original. And those are called thumbnails. So Perfect 10 versus Google and Kelly versus Aribasoft were two cases in which thumbnails, which with just smaller versions of the originals, were ruled to be fair use. But anytime you see an amount like 10% or 30 seconds or 1,000 words or 3 minutes or whatever, that's generally a guideline, and those guidelines have not held up in court. Guidelines are kind of an old-fashioned late 1990s idea. So when you hear that or you see that, that's not in the law. People will say, well, I want to use 10%. Well, okay, 10% could be infringing, or using 50% could be not an infringement. So those guidelines aren't very good. They're not a safe harbor. They don't offer a safe way to get by with copyright. And this is the big case. This is Richard Nixon. I always like to mention Nixon in one of my talks, at least once. But in 1979, President Gerald Ford wrote his memoir, A Time to Heal, was published by Harper & Row. Time magazine had contracted with Harper & Row to publish excerpts from for this memoir to try to boost sales. Well, The Nation came along and they scooped Time magazine, and they included quotes about Ford's reasons for wanting to pardon Nixon. Instead of just letting it go on, he wanted to heal the nation. Well, this, of course, this is what people were interested in reading with this book. I'm not saying Gerald Ford didn't have an interesting life. Sure, I'm sure he did, but this is why people tune in. This was what's called the heart of the work, and the court found that this was copyright infringement, that Harper & Row lost sales because of this. Harper & Row had to prove that they lost sales because of the quotes that were scooped by The Nation. Plus, Time magazine was mad, so it was like this general anger fest all around. But this is a great illustration of what's the heart of the work, something that can affect the sale. And we're going to move on to the fourth slide, which is exactly that, the effect of the use on the potential market. So this comes up constantly, where you've got this market for a work, and somebody really scoops that market. There are very obvious examples like a CD that's been duplicated and, you know, shared on a network, or, you know, even sold on a street corner or something. But then you've got this other kind of thing where there is no way to get permission for using the work. The work is still under copyright. You can't reach the people who used to own the copyright on it, or still do own the copyright. Maybe the heirs won't answer your email. So you've got this orphan work situation versus you've got a ready market for something like a textbook. So a lot of the cease and desist orders that come to us are cases like this, wherein, you know, university council receives a notice, or maybe our licensing people receive a notice that somebody took this textbook and scanned the whole thing and put it up on our server. Obviously, that's never going to be fair use. But let's say it's an old textbook. All right, so we've got a textbook from the 1960s, and it's a mathematics textbook that explains mathematical concepts really, really well. And it's not in print, it's not for sale, it's hard to find on the used book market. You have a lot better case for scanning some of those chapters and putting them on whatever your course management system than you do for a book like this that is intended for sale. Also, if you've got things like workbook pages, those are really kind of this item that people want to keep consuming. So this is another example of that, the effect on the use, the effect of the use on the potential market for the work, or something that isn't being marketed. So I really love this is a classic fair use checklist. You've probably heard of it. Kenneth Cruz, formerly of Columbia University, now retired from Columbia and working for a law firm in LA, and Dwayne Butler put together this fair use checklist, which has a Creative Commons license on it. You're allowed to take it, you're allowed to use it. We adapted it for Kent State. I made it a PDF that we can fill out. And somebody who's better with Adobe Acrobat actually made a prettier one, but this is mine, and I use this quite a bit when evaluating fair use for digital projects. So there's a couple of versions out there that we have that you can create your own, and that way, you know, it's Kent State's, you know, but we've also cited the fact that this was by Kenny Cruz and Dwayne Butler. They originally put it together. So there's an idea for you. Getting a feel for fair use can take quite a long time. It took me several years before I really felt comfortable with what I think about fair use. One way of doing that is to study it. The US Copyright Office has an index of fair use cases all over the country, ones that have gone to district courts, ones that have gone to appeals courts, ones that have gone to the Supreme Court, and you can sort them out at this index. And you can kind of read about them. So if you're facing an instance that's similar to something you want to do, or if you just want to get a feel of something, you can go there and you can look. The Stanford Library has a summary of fair use cases, which is terrific. You can go there and read the summaries, and that'll teach you a little bit, and you get a feel for how the courts think. Of course, courts tend to surprise you. We'll talk about that in a little bit, but it gives you an idea of what might be the boundaries of fair use. And those fair use forms that I've supplied by Kenny Cruz, the wording in there actually refers to certain wording that was used in court cases, because only a court case can decide whether something's a fair use. So that gives you kind of a feel of fair use. There's actually, if you've never watched this, it's something that maybe you'll want to watch the first 30 seconds of. It gets old really quickly, but it there was a test of fair use. I think they really wanted Disney to sue over this. So this was college in Pennsylvania, I forget the name of it now, but a student put together, like actually looked for little clips from Disney cartoons, and they put together this fair use tale that kind of uses these little tiny clips to put together sentences. It does get irritating after a while. They put it under a Creative Commons license now, but I actually met the student who picked out the Disney clips to do this. And I'm like, oh, I need your autograph. This is great, you know, but they were trying to get sued to make a point in court. And of course it never happened, but there's this artifact here and it kind of does give you a little bit of a feel. So if you're into it, watch it later. I'm not going to show it now. It's 10 minutes long. This is a fair use curveball that we discussed earlier this week, actually, but the Second Circuit Court of Appeals ruled on Andy Warhol's use of a photographer's photographs for Vanity Fair. They ruled that these were not fair use, and that was actually kind of a sad situation, because the photographer didn't know about this until after Prince died in 2016. Then she discovered that her photos were licensed by Vanity Fair, turned over to Warhol. Warhol did this. And the court said this isn't so transformative because her photographs did the same thing. They presented, you know, Prince in this kind of dramatic light. So, the court ruled that this was an identical overarching purpose, that the photographs weren't changed substantially enough to make it a different purpose or send a different message. So this might be appealed, and you know, we're watching this really, really closely. But the Hollywood Reporter does a great job with writing up some of these cases. You can, you know, read them and see what you think yourself about stuff like this, but this was a surprise case that came up. A little bit about fair use here. You will get any first-year law student saying that fair use is not a right, that it's used as a defense in U.S. courts of law. Yes, it is. It is used as a defense in U.S. courts of law, and you can see that illustrated over and over. Is fair use a right? Well, some people will argue that fair use is a right because it's a safeguard to protect the First Amendment, according to the Supreme Court. And we saw that with the Wisconsin protest T-shirt. You know, this is a First Amendment way of sending a message. It's certainly a safeguard of the First Amendment. If your intended reproduction or use is not covered by some part of the U.S. copyright law, you can take a look to fair use. We call that the fair use savings clause. And people who would want to rework some of the law, like some of Section 108, really want to get rid of the fair use savings clause. They don't want to have people using that. They want people to just stick to what the law allows and nothing else. Well, that would be very hard because you've got these, you know, orphan works that may really be important to education or important to other endeavors, and you can't reach anyone for permission. So do you take that risk? Well, you know, I think your institution needs to decide, do I want to take that risk? You know, you need to work with your own counsel and figure out what are the parameters for that. But certainly you can make a fair use argument for a lot of these things. And we'll go through some examples of that in the afternoon session. Fair use evaluations do not carry the weight of a legal decision, of course. They're not a substitute for the advice of your attorney. But let's say you think something is fair use and it happens to go to court. You bring those fair use evaluations, your documentation to the court, you show it to the judge, and the judge could say, I see that you really thought about this and that you really put a good faith effort into complying with the law. So we are not going to charge you those statutory damages. Even though we found that you've made an infringement, you will not owe the money. So that's a good thing. So that's a good reason to think through that fair use evaluation and hang on to the documentation. And, you know, I can't provide legal advice, but what I do tell to faculty is think through this using this form. And the people who really love the form are like philosophy faculty. They're like, oh, I love this. This is a great way to think about things. So, you know, philosophers love it. Other people get confused by it, but I think it's a great thing to become very familiar with, you know, what is on the side favoring, what's on the side opposing, and where do those cross, because they do cross over quite a bit. So I want to talk now about licenses. So this is an abrupt shifting of gears. Like I think I jammed the gears on my my standard transmission here with this, but licenses are what we're dealing with now, because licenses are a way that publishers have found to kind of get around the law a little bit, especially in the electronic environment. And licenses can supersede the law. There's such a thing as an unconscionable license, where the matter inside the license just doesn't work. Again, Tom Lipinski talks a lot about that, but licenses are agreements between parties, between the copyright owner, not necessarily the creator, of course, and the end user for the use of materials for specified purposes. So if a license is silent on something, you look to the law. But if a license mentions a particular kind of use, you're stuck with that because you agreed with it. And the most famous example I can think of that frustrates people to no end is Harvard Business Publications that are in EBSCO. Harvard does not follow EBSCO's license, so you're not allowed to use these in courses, and it just really upsets everyone all the time. So people are looking for open access case studies, and other kinds of business information, right? Because Harvard really wants to deal with the student individually. So you've got them in there for what? I don't know, just to look at, but you don't have them in there. You can't even go through and say, this is how you access on EBSCO the Harvard case studies. You're not even allowed to do that by license. So to me, that's unconscionable, but I guess maybe not to the law. So keep in mind that licenses are kind of the answer to some of these rights, these exceptions to the exclusive rights of the copyright owner that companies have come up with. Creative Commons licenses are something that have been an answer to commercial licenses, wherein some rights are reserved. Now, if you've got a Creative Commons license, the Creative Commons people are not tracking these licenses. Like you can register your work for copyright ownership, but the Creative Commons people don't keep track of your Creative Commons licenses. You simply come on and you label something as Creative Commons license. But you got the same idea here with the double C's in a circle, and they say some rights reserved. And what I like to say is that to the people who are trying to use something that's got a Creative Commons license, without first asking the copyright owner, you may do the following under these conditions. The copyright owner could come out and say, you can use this, just say it's by me. Or you can use this, just say it's by me. And if you create something based on that, license it the same way. Or the copyright owner can say, you can use it, you can say it's by me, you cannot make any changes to it, and you cannot use it commercially. So these Creative Commons licenses go from super flexible to super strict. And that's the way they run, and you can check those out if you have not done so. Here's an example of a commercially licensed image. I wanted jelly-filled purple cookies. Okay, that was my idea here. So I searched Getty Images, and Getty Images is pretty strict with their license. They will license you an extra small, what we think of as a thumbnail, for $50. But this, they won't take off the that watermark or the Getty Images thing until you buy the image. So here you have these they're actually not cookies, they're macarons. I hope I'm pronouncing that right. I don't eat them, I'm just not that fancy. I certainly don't make them in my kitchen, but they're pretty, right? So this gives you an idea of what commercially licensed images can do for you. You could have a Creative Commons licensed image, and you can actually search for Creative Commons images, and also music. There's some great music out there by, a lot of the famous stuff is by Kevin MacLeod, and that's Creative Commons music, and you can use it. And also some video that you can use. And the image search wasn't that great when it started off, but people are really contributing to this and putting a lot of great stuff in there. So there's a lot of stuff you can use that all you need to do is, cite the person and put the Creative Commons image or follow the Creative Commons licenses, and you can use that. And it's a great alternative than to just finding something using Google and not knowing what it is, or finding something using Google, finding out it's Getty. So this is something to look for. I show this to patrons and to our faculty all the time. Here's the jelly purple cookie that I searched using Creative Commons, and you have these blueberry jam cookies, and they're licensed by the person who took this photograph. This is a pretty strict Creative Commons license. I'm allowed to use the image. I'm allowed to, if I use it, I have to say who it's by. It's by this 3 Liz 4. It's got a pretty strict license. I cannot use this commercially, and I cannot create a derivative work. So let's say I wanted to change up this image a little bit, like maybe changing the colors, changing the background, really putting it in a different setting, perhaps putting it on a wood table like that Getty image. I would not be able to do that because I would be creating a derivative work. I couldn't make a Happy Meal toy out of it. So you cannot create a derivative work. What I could possibly do is contact 3 Liz 4 and ask her, I really like this image. Here's how I want to change it. May I do so? Creative Commons doesn't like these strict licenses. They will scold you a little bit and they will tell you this is not a free culture license. So when you try to apply a license like this, they give you that little, yeah, we don't like it, but you know, the work is still out there and you can still use it. And that's the difference between something that's licensed through Getty and licensed through Creative Commons. Now it's time for our other quiz. And I'm such a mean person because I'm doing this before lunch. But my question and my quiz question for you is, which image do you prefer? Do you prefer the image that was licensed by Getty, or do you prefer this Creative Commons image? And for contrast, I'm going to flip you back and forth between the macarons and the first Getty image, or do you like the Creative Commons photo? Which looked best? Oh my gosh, and we have like nearly a 50-50. But yeah, I mean, sometimes when you pay for something, it does make it more appealing. I see a lot of you like Creative Commons and maybe you'd rather eat these cookies. I kind of get the feeling that if these cookies are homemade as opposed to the macarons, which might contain artificial coloring or some kind of bitter taste, maybe these would taste better. But these are the results. And thank you for participating in that very, very cruel poll. So we will move on now to the next slide. There are rights statements now for digital projects. And what these send out the signal of is rightstatements.org has these rights statements that talk about whether a work is in copyright, whether a work is not in copyright from your determination, or whether the copyright status is unclear. And so there are different rights statements for different copyright statuses. These are used in digital projects. We've used them pretty extensively in our digital projects. That's something to take a look at. For me, those little symbols look like the Partridge Family. I don't think that's a derivative work. I just think it's a happy accident. But I think of the Partridge Family. There are 12 separate statements that will apply to different circumstances. So that's something that's being used. The Internet Archive and Controlled Digital Lending. I want to talk about this because this is such a cool concept. You know, when COVID came out and nobody could go to a library, the Internet Archive put out what they called the National Emergency Library for COVID-19. So the Internet Archive decided we're not going to put any limits on the books in the Internet Archive collection. We are going to put them out there for unlimited loans and people can just go and use them. And of course, I think it was the Authors Guild or the Authors Alliance. They hated that, and there's a lawsuit now, but this was a great way for us to fulfill some requests for books that we were not able to fulfill in person using the Internet Archive. So this is a pretty cool thing. Their open library has 2 million volumes as of February 2021. You can go on there and you can borrow something for a short period of time. I've used this in my work to look at particular works, usually to look at copyright statements, but anybody can go on and use it, take a look at it. You can't download them, and then they return for you in about an hour. There's also something now that's enabled by the Internet Archive, certainly not invented by the Internet Archive, but certainly enabled by the Internet Archive, called Controlled Digital Lending. And that's the idea that utilizes Section 109. Remember the right of fair use? where you are allowed to lend out the copy that you bought, or you're allowed to destroy it. So the idea behind controlled digital lending is you scan the book into whatever system it is. It doesn't have to be the Internet Archive. And you lend it out to people on a 1-to-1 ratio. It's called owned to loaned. So it's clever. But you've got that 1-to-1 ratio where, okay, so you only bought one copy. Well, you're only lending one copy. So if you've got the digital copy loaned out, you don't lend the print copy. If you've got the print copy loaned out at the time, you don't lend the digital copy. And your libraries books can be made more available that way. And especially during something like a pandemic, this is really such a cool idea. And you can take a look at Brewster Kahl's article about it and EDUCAUSE. And I think it's probably the next step. And, I hope we're going there. And so these are some of the ways that libraries can make use of digitization creatively. So at this point, I'm going to turn it over to questions that you have. And if you've got a question that requires an attorney, I'm not going to answer it. If I don't know something, I'm not going to make something up. I'm going to say I can look that up. So if we want to open it to questions at this point, we can. And I guess what I'll do is end my slideshow because I can't really see anything other than my slideshow when I'm looking at my slideshow. So.
Thank you, Cindy. I have some questions that were asked in the chat while you were speaking that I was going to go through first. And then if anybody else has questions during this time, pop them in the chat and we'll get to them. So the first question was about the reference librarians at KSU. Do any of them have law degrees and could help with these sorts of questions?
Yes, I have a colleague, in fact, my boss is a lawyer. She got a law degree from University Akron, and her law degree focuses on labor law. She wasn't really looking to get into IP. She's taken a couple of what they call CLE courses. I don't really rely on her as much as I rely on University Counsel, because we've given workshops together and her attitude towards fair use is a bit more conservative than mine. And the workshops that we give together are actually very dynamic because we'll kind of argue with each other. I think this is fair use and this is why. And she'll say, no, it's not. And this is why. There's nothing wrong with that. It's a lot of gray area in law. And a lot of it is, it depends. And you just don't know which way the court's going to go. I tend to side on the what helps along the progress of science and the useful arts. So you see where I go back to the, what's in the Constitution. But I think she was one of the first people who said to me, fair use is a defense in a court of law. That's how she is taught. And I think that's how most lawyers are taught, unless you kind of go into legal studies and then you actually get on the side of using fair use. And there are probably a lot more attorneys who are on the other side than attorneys who are on this side. But there's a big band of lawyer librarians who are on this side. And I have friends who are in that, and I consult with them when I need to, and they're a blessing to have.
Okay. The next question's related to the what cannot be copyrighted slide, and it was asking about tangible medium, if that includes digital items as well.
Yes, digital items are tangible medium. You may need a machine to read it, but that's definitely a tangible medium. You've got the case where you used to be able to, hold up a film strip or something to the light and see that image. That was definitely tangible without the machine, but certainly a movie or a computer program, all of these things can be copyrighted, and that is a tangible medium.
Okay, thank you. We have a question about section 110. Can you use that to use streaming video in a class?
Well, that's really that's a difficult question, and it sometimes you can, and it really does depend. This is an it depends. You've got to read whatever license you were given by whoever sold you or rented you the streaming piece. Amazon Video, I actually emailed them once and I said, hey, Amazon, can my professor show something that she bought through Amazon Video to her class? And the guy on the other end was like, well, sure, all she has to do is bring her computer up and, talked about the screen projector. And I'm like, no, 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 no. How about the license? Because the license isn't specific. And he said, yes. So I took that as a yes. And I told the patron yes. But you really need to be cautious because Netflix does not always allow that. Netflix allows some classroom streaming for some reasons. And you have to look on their list of things that are allowed to be streamed. There was one thing that somebody wanted to show and it didn't appear on their list of approved things to be shown in the classroom. So again, I contacted them and I said, this is something that somebody wants to show. Can they do it? Oh, yes, this should be on that list, but it's just not yet. And that was the response. But, you really do have to be kind of cautious with some of that. Can people take a DVD? This is the question I get all the time. Can people take a DVD that the library bought, rip it, and put it up on streaming and show it in the online classroom, like distributed through like your course delivery systems? And that's something that copyright librarians everywhere are struggling with. It's something we don't like to talk about. It's something we talk about privately to ourselves. It's something where some people will say, no, we can't get past this part of the law. There are other people who say, well, we get past this part of the law because of the split circuit on whether you can break. It has to do in, there's a part of the law, I didn't intend to talk about this, but section 1, was it 1201, which talks about not breaking these copyright controls that are built into digital media. There's really a split at the appeals court level, I believe, where some of the courts have ruled that section 1201 is subject to fair use, whereas some courts have ruled no, 1201 is not subject to fair use. So remember, fair use is a limitation on the exclusive rights of the copyright owner. So some courts think that 1201 is subject to that and some courts do not. So some people do it, some people don't, but people do not like to talk about it. Sorry.
Yeah, there's a similar question here. Has anyone done digitization of DVDs that they own to provide controlled digital lending of those materials during COVID? And that feels a little like an it depends.
That's a big it depends. And, I don't know. I know we're not doing that. I do know that some people have, there's a difference between ripping the DVD, I guess, or like watching the DVD and capturing it. Some people think there's a difference there. So yeah, that's not, check with your institutional counsel.
Okay. We have a question. If someone does not have children or grandchildren, and there's no designation in a will, who will inherit the copyright?
You can work out your will with your personal attorney, and a lot of times people will put their inheritance into the hands of like, I have one. I have an example for you. FDR. I tried to clear a copyright for somebody, and basically, FDR, Franklin Delano Roosevelt, he's got heirs, but basically they've turned all those rights over to the FDR library. He's also got publications that were renewed. The copyright was renewed for them. During the time that he was president, he published these privately. The publisher has been since bought or sold. So if the copyrights are now owned, inherited by the FDR library ought to be able to say, you can go ahead and use this in your publication, but they did not want to. So yeah, you've got this kind of like circular reasoning there, and that's when the machinery jams up, the machinery being everybody's brain. But yeah, you can just sign over your copyright to whomever you want to own it. Like I could sign over copyrights in my holdings to Kent State University libraries or even to a third party. I might sign them over to Virginia Dressler. I don't know. We'll see what happens. Yeah, they can go to anyone. But as a default, they do go to your heirs.
Okay. We have a question about orphan works. Can you provide a good definition of that?
Orphan work is something where it's still under copyright. The copyright hasn't passed, but either the owner cannot be contacted because they're deceased, or you can't find an heir, or the copyright owner you know is alive and you can't find a contact for them, or you find the copyright owner, but they won't respond to you. And that's an orphan work. That's my definition coming out of my head. There's a really formal definition that you can go to on copyright.gov, and you can get like a scholarly one.
Okay, thank you. We have a little bit of a longer question about e-reserves. How do we work with faculty regarding what goes on e-reserves if we can no longer say 10% as a general guideline? Do you require faculty to fill out fair use checklists for every copyrighted work submitted every semester?
So I don't manage e-reserves anymore, but I do still work with them. And I try to, guide what goes on to e-reserves. Again, I think, you have to take a look at fair use in a holistic way. How old is the book? Is it still in print? Are there lots of circulating copies out there? Can I get a copy very cheaply through a used book source, which a lot of times you can? Or is this book out of print and no one can find a copy, or perhaps the copies are really overpriced, like, we're talking out of reach of the average person, and whatever price that is, $500 may not be something your own library is willing to pay for a book. So that's not something that you can really judge. You're given some flexibility there. Versus something like a textbook that is for sale, readily available. Maybe it is expensive. Maybe it's $250, but this is how the publisher is making their money. Versus something that perhaps it's an older book, it's readily available for sale for very inexpensively. I'm not a big believer in scanning everything for e-reserves. I think there are things that people can get on their own, and the secondary market can benefit from that. But I think you kind of have to, in a way, if you're a manager of reserves, you've got to handle a lot of volume. We have not made our own faculty fill out fair use forms. We generally do that on their behalf, or we generally, we take, if somebody wants us to scan and have a larger portion, like say 2 chapters, 3 chapters, 4 chapters, we do take a look at those things kind of on an individual basis and make a judgment based on other factors. It's not just amount, it's, recency, it's whether it's in publication. It's a lot of things. All those factors go into the decision.
Okay, I've got 2 more questions for you. And I don't know if Nate got any separately, so we can weigh in about that afterwards. These are both related to social media. The first one is, what does it mean when people on Facebook say, I don't own the rights to this music? Does that absolve them from litigation?
That's just something that the kids say, I don't know. Like the kids will put together a cute video and, they'll use the music or whatever. And some copyright owners really come down with full force on those people, and others just let it go. No, it doesn't absolve anybody from anything. Usually there's a takedown notice. There's a famous case involving Prince again, where there was you guys have probably heard about the baby video, where the baby had just learned to walk. baby was running around the kitchen island, maybe pushing a little toy cart or something. And Let's Get Crazy was on in the background, and Prince's estate sued, or maybe the record company sued while Prince was still alive. I'm not sure which one it was. But that ended up being fair use because the music could have been anything. The music wasn't terrific quality. It was just background music. It wouldn't substitute for the original. You wouldn't go and put that video on if you wanted to listen to Let's Get Crazy, because there was baby noise. There was like, oh, all those other kinds of noises that go along with a video like that. So no, it doesn't necessarily absolve somebody. Anybody can sue anybody. This is America, but usually it's a cease and desist and a takedown. But no, that statement doesn't really count for much.
Okay, last question. For social media purposes, how do you know which images are fair to use? How do Wiki Commons images compare to other images found during a Google search?
Well, I think you really have to go back and try to find where the original image comes from. You can try to do a reverse image search using Google. There's like another tool out there, like something 10i, I think, that allows you to do a reverse image search. And if you can find the original owner, you're good. I think if you're on Facebook and you're adding things, you're probably in good enough shape. Facebook does get takedown notices where like sometimes you'll repost something and later somebody will come along and you'll try to look and see that and it'll say, oh, the original person changed permissions on this. Maybe that was a takedown. I've seen that done with like photographs. Somebody will take a snapshot of a poetry book and then put that up on their Facebook, and those sometimes get taken down. Other people realize that their copyrighted works have become a meme and they can't control it. Once the cat's out of the bag, it's really hard to control what happens with a meme. You've got the Grumpy Cat who, passed on, God rest her soul, where people created memes out of Grumpy Cat, and Grumpy Cat owner didn't really care about that. But what she did care about was licensing. So she wanted to sell like stuffed Grumpy Cat with like the Kent State bandana around its neck. And so she licensed works. She also sued a coffee shop for misusing Grumpy Cat coffee. She had like one kind of Grumpy Cat coffee permission. The coffee shop tried to use it for another permission. So, it really, it depends. But I think that now we're in this digital world, the cat really is out of the bag, and maybe it's best to leverage it rather than try to stop it.
Yeah, that kind of reminds me of the Pepe the Frog. There's like a documentary about it now, how it got like co-opted into a white supremacist hate symbol. And the artist was like, no, I don't want this.
No, I know. Think about that. Think about the fact that, that's it could be a visual rights act thing. But, the minute something like that gets out, it's very, very hard to control. You can try, but yeah, that's really a terrible what happened with that, because that's the minute I see that thing, that's what I think of. Yeah. And I don't necessarily think charitable thoughts, but gosh, compassion for the original creator.
Okay, I've got one last question for you, and then we can head to lunch if there's no further questions. It's about the faculty filling out a copyright form before putting something on course reserve, or if someone else is doing it on their behalf. What do you do with the form afterwards? Do you save them?
I think it's a good idea to keep those forms. I think in the state of Ohio, the statute of limitations is 3 years on a civil suit. So generally we hang on to those things for 3 years, and but it kind of depends on what your council requires. I think some paperwork our university council wants kept for 5. So that's something that you would have to kind of decide, depending. There was the decision with the Georgia State University e-reserves case came down, and I think we can look to that for some guidance, and we can perhaps I know it was remanded back and forth a bunch of times because the courts really don't like limitations like one chapter they're not really fond of, putting that on there, but they found just so few cases of infringement in there. So to take a look at what they thought was infringement and, to kind of re-examine that would probably be a wise idea. But, bear in mind, it's the slimy thing that's hard to pin to the wall. Now I'm calling it slimy because, but yeah, it's a gray area and it does depend.
I guess that's all the questions.
I'm
Okay.
sure you have more. You can always email me a question.
Well, thank you, Cindy. That we appreciate it. Please note that we're going to keep the Zoom open for lunch. It will not be recorded. And we hope to see you back here promptly at 1:30, and I hope you have a great lunch. Okay.
Recording on.
Okay. All right. Well, good afternoon, everyone. We now welcome back Virginia Dressler and Cindy Kristoff for our next and final presentation, Copyright and Digital Projects, Considerations and Evaluations. As a reminder, this presentation will be recorded. Again, Nathan and Chloe will insert poll questions and moderate Q&A at the end of the session. So with that, I give you Virginia and Cindy.
All right, thank you. I will bring up our slides.
Jenny and I switch off on this one.
All right, and I think Cindy kicks us off.
I think I do too. So I think with copyright and, there are other considerations with digital collections too. And I think it can kind of feel like you get stuck sometimes. And you can move to the next slide. And whenever we got stuck, sorry, I couldn't help but use this. We would talk things through. We would have a lot of long conversations in, the conference room about what should we do with this? Could this be a fair use? What if? We had a lot of what ifs. Who is this person? I can't find them because, it's a woman and I think they got married. We had some troubles but we talked through them and we problem solved and we tried to keep in mind what the mission of the digitization project was and how is this going to help people. So hopefully that worked in our favor. I'll again remind you, we're not lawyers, so this is not legal advice. Just because we did it doesn't mean you should do it. It's just talking about why we did it. And if you have questions, definitely consult with your institutional counsel.
All right, so I think we have a very quick poll question to start us off before I go to the next one. Cindy and I were curious, out of this group, how many folks deal with copyright on regular or not so regular basis? So we'll give a couple minutes for folks to do that. I thought I'd also mention too, while Cindy and I are presenting, we wanted to leave some time at the end to really hopefully have some good discussion, maybe share some issues or anecdotes. If there's anything you're not comfortable with having in the recording, you can put these in to the folks monitoring the chat so they could read those out kind of more anonymously. So it depends on that. So I see stuff coming in. It's good. I know I was, when I started at Kent in 2014, I think I was teasing Cindy that I was kind of afraid of copyright. So I have learned an awful lot working directly with Cindy this last 6 or 7 years I've been at Kent.
That's good news. I hope they've been good things you've learned.
They have all been good things. I don't feel scared.
Okay, good.
I sleep better at night.
Excellent.
All right, so I think we've got most of the folks who have voted. So I think we can end that. So it looks like majority of folks say sometimes. So that is good to know. Some frequent folks, some rarely, and some never. All right. I will go to the next slide. Okay, so where Cindy and I were going to start today was really talking about some of the different ways we've incorporated copyright reviews before publication on a digital repository or a digital platform. I kind of emphasize the word before because there's certainly some approaches that kind of go with the idea of putting things up without a copyright review and waiting for a takedown notice or request. But we've really been, I think, pretty adamant about taking the time to put this copyright review into our day-to-day practice that we wanted to share with you all today. We'll talk a little bit about, I think, 2 specific grant projects that's kind of pushed some kind of systems updates that may or may not be of interest on how to kind of incorporate this copyright review more into our digital collections platforms. We'll talk a little bit about selection and copyright, how an institution type or your institution's kind of tolerance to risk around copyright may be a factor too. We'll talk a little bit about preservation scanning as an option when copyright does not allow for open distribution. And I think Cindy mentioned the last 20 this morning, so we'll delve a little bit more into that with the kind of lens of digitization. So I think I turn this back to Cindy for the next one.
So this is one of my favorite things that anybody has ever said in a court case. You know, I do read fair use cases for fun. And so this actually appeared in a case, and I just think it's one of those things like with the constitutional, aim of, what was the original purpose of intellectual property and copyright. It reads, the law was agnostic between creators and infringers, favoring only creativity and the harvest of knowledge. So again, I know it's a little corny, but these are the kinds of things that I look to when I'm trying to make a decision. Do we share it? Do we, will this do somebody good? And, how we think about that, how we think about the possibilities of the use of materials, I think can really help. And I know catalogers do that all the time, right? You think about the possibilities of use. So just a little thing I use, a little trick. So these are standard questions that people who are working with copyright ask. And these have come from a number of places over the years. I first encountered them when I was doing copyright training with Carrie Russell to be part of we had like a CAN copyright advocacy network. And so we went and did a lot of education. So these questions first appeared there, and then I saw Kevin Smith cite them, and then they were cited in Copyright for Librarians and Educators, the Coursera course, the online course. So you see them over and over, but really, when you think about copyright, this is the way to think of it. And this is the way to get a good feel for it. Standard questions. Is the work in the public domain? If the work is in the public domain, you're free and clear. So that's a really, really good thing. The trouble with modern digitization projects is things aren't usually in the public domain because, the digitization project is modern. We face this a lot with May 4th. Even though May 4th occurred before the 1976 Copyright Act was enacted in 1978, we still had to deal with changes in the law that happened very quickly after the 70s. So there were a variety of different aspects of the law to look at. Is there a license, and does that license allow for your use? We don't use this very typically with digital projects unless it's a Creative Commons license. And we don't typically deal with Creative Commons license things that are as old as something like the May 4th project, because they didn't have that then. Maybe people who are writing and creating now with things surrounding May 4th, would license something Creative Commons, but we don't have that. Commercial licenses, we're not really interested in putting up a licensed work, that's in our databases. That's not really what this is about. These digitization projects are for materials that aren't available commercially. We've got hidden in our collections that we want to make available to the public. So licenses don't, I kind of skip over that one. Is there a portion of the US copyright law that allows your use? And, there are places where you're allowed to make copies, but there really isn't much mention, is there, of any mention of digital projects in something like copyright law. And the law has not been updated for that, although there has been the Digital Millennium Copyright Act that was, just a little, wasn't what we're dealing with here. So we think a lot about fair use in these terms, but yeah, we do think about things like the last 20 years and, Section 108H, which we'll talk about later. Can you make a good case for fair use? And that's what we try to do. Or do you need to seek permission? So that's the order in which they go. Now, we altered them a little bit for our digital projects. And let's see, this is, I thought we had another slide in there, but anyway, yeah, Peter Hurdle actually has a workflow that's really excellent. And it follows along the lines of these questions. And it's called the Safe Digitization Workflow Chart. And I think that came with your handouts. And really, they start with the question of, does the institution own the copyright to the material? Well, that's just as good as, something being in the public domain. So public domain quickly follows. And then their protocol to decide, does this really fit in with fair use? Taking a look at the different factors. So we had to forge, to really organize our work, we had to forge ahead. And unfortunately, I didn't discover this flowchart until well into the project. And I was like, oh my goodness, this is a lifesaver. So any of you who are going to be working on that, I would like everyone to see this flowchart and things like it.
Yeah, so we sent that attachment, I think, so we could see full screen, because I think we've got a slide, but it's harder to read.
Oh, squished up.
Yeah,
there it is.
yeah.
So yeah, it starts off as the copyright, do you own the copyright? And then if it's not, is it in the public domain? And then, okay, what do you do? What are there exceptions? And then if there's an exception, can you use fair use? Now, one thing that Peter Hurdle adds, and we all add to our digital project, is if you ask permission and don't receive it, if you ask permission and get a no, if you ask permission and you get it, but only at an outrageous fee that your grant or whatnot can't afford to spend, what do you do then? Do you not put it, or do you digitize it and put it in the dark archive that Jenny was mentioning? Or do you do fair use again? And you can do fair use after somebody has refused you a permission. You can still evaluate it for fair use. You should still put that in as part of your fair use evaluation, that there was no licensing available for it. There's no way you wanted to, you were willing to. And if you think about it, that's what 2 Live Crew did with Ray Orbison, and they won their case. So next slide.
Right, so we wanted, oh, go ahead.
Go ahead.
So we wanted to share out, this wasn't something that these grant projects will share in our examples later, was around when we were working on it, but Cindy and I were so excited when Berkeley put these out, I think just about exactly a year ago. They called them the Responsible Access Workflows. They addressed 4 different areas, copyright being one. This is one of the handouts that we sent to. I think the really kind of fantastic thing about these is that they're templates that you can adapt for your institution. And I think, I don't know, Cindy and I were kind of geeking out about these because we were like, oh God, these would have been amazing to have on hand when we were working on our grant in 2016. But things that we can absolutely still incorporate and use, every day. And then, so outside of copyright, They also have contracts that if you're in special collections or archives might be a really good resource for you addressing gifts, purchase agreements, records transfers. These are, big kind of decision trees, but I think are really great prompts to get folks thinking about, some of the issues we might not always kind of have on our mind. The privacy one to me, I think has been especially interesting. This has been kind of my research topic the last few years, is privacy in digital collections, but really thinking about what kinds of information can be considered private data that you wouldn't want to share out on an open repository, that you'd want to redact or restrict in some ways. So especially if you're in education, this includes some FERPA specifics that are really good on types of information to restrict. Other things like social security numbers. Here at Kent State, we had our student ID numbers, I think until 2006, were social security numbers, which did not look like social security numbers at the kind of face value, but they were things that we certainly didn't want to share out, whether that was a conscious or unconscious decision in our digital media. And then this privacy torts, which kind of goes down a whole nother avenue of kind of legal protections around nudity, legal activity, and other kinds of personal private information, religious information, that sort of thing. And then the ethics one, I think, is equally as interesting as the privacy from my point of view, because these are kind of the grayer areas that we don't, as practitioners, I think, especially for digital librarians, we don't have a lot of guidance in some of these areas. So I definitely encourage you to check these out. We didn't want to go too far into these, but we definitely wanted to point these out too.
I will say that Rachel Sandberg is such a friendly person. For her, this is still a work in progress. And so she's still looking for input. I'm not saying this is draft, but she was very relieved. We all got together for like a little kind of private meeting. We talked about what we did in our libraries, and she was like, thank you for your insight, because we're all facing the same thing. We're all going through the same things. We're all forging ahead with these processes. So this is the standard questions as we adapted them for the May 4th project. And you can do this with any project, I think. Is the work in the public domain? Well, public domain is so hard when you are talking about archival materials, because you're talking about unpublished materials, and unpublished, never published, those are still owned by the copyright owner, even as far back as, something like May 4th. And then you have to think about the definition of published. There's so many factors here. So public domain can be really, really hard to determine in this case. Certain things such as, for the May 4th project, such as the photographs that the State Highway Patrol took ended up being in the public domain, and we could use those. But you have to be careful, because government documents, US government documents, are in the public domain. But the things like, other state government publications aren't necessarily in the public domain, and it varies by state. And yeah, there's a chart for that too. I think that one is at MIT. I could be wrong. Katie Zimmerman worked on that project, where all the states have different rules for what's in public domain and what isn't.
Cindy, really quick, I hate to interrupt, but there's a question in here. If you could just, I'm sure most of us know about May 4th, but if you could briefly explain what that is.
May 4th, yes. Jenny, do you want to, or do you want me to?
Sure. Trying to remember it. So May 4th, 1970 was when the National Guard was called in. I think they came in on May 1st to campus after protests. It was the invasion into Cambodia. Is that right, Cindy? That was the kind of reason for the students gathering on May 1st through 3rd. There was a lot of destruction on campus, downtown. So on May 4th, 1970, after I think a peaceful gathering around noon, the National Guard shot and killed 4 students. I grew up in Kent, so I feel like this is kind of ingrained in my being. So I know we say May 4, and I hadn't even thought about putting an intro in, so my apologies.
Think about it either. I guess, you know, the May 4th shootings are so much in my mind. They're so close to us that it's hard to see from, you know, 10,000 feet. I apologize for that. So yeah, if Kent State owned the copyright to something, then we would go ahead and we would put it up. And there were a lot of things that Kent State did own the copyright to, such as you know, meeting minutes, like faculty senate meeting minutes, or, you know, anything like that produced by the university. There were other really amorphous things. There was a call right after May 4th happened, like really immediately, where I think it was the head of the library asked other institutions to send in materials surrounding the May 4th event. So if anybody on another campus had a protest, or if there was a flyer or a little, you know, newsletter, you know, attend this protest, or, you know, here's what's happening in your area, or here's what's happening in the world, here's what's happening in campus, come support the effort, you know, remember Kent State. There was a lot of this happening. So people just sent in all kinds of things. And this letter, I had been hoping that this letter had contained something about copyright or rights to use it. And of course it didn't. They weren't thinking in those terms at that time. So, you know, we had a lot to wrestle with. And there were times that we would seek permissions, and sometimes that we would find it impossible to. And sometimes we would find it impossible to. So we'll talk a little bit more about that as this goes along. There are best practices documents. One really big important one is the ARL best practices for libraries, and that's right on the ARL website. It might be in your materials you received, not the whole thing, but there are best practices for digital projects, and that's one thing that we used as a guiding light to help with our fair use. Do we need to seek permission or a license? Well, sometimes we did. Sometimes if what it was a newspaper clipping that was, you know, from a newspaper that was like a big newspaper, and we were like, okay, should we? So we would seek permission for things like that. And then if we could not obtain permission, do we look to fair use again? So we followed those as best we could. This is Peter Hurdle's public domain chart. This is just a repetitive, but it's to remind you this exists, and this can serve as a beginning guide to it. This is blown up, and the reason why this part is blown up is because changes that occurred in US law throughout time have led to these quirks in what becomes in the public domain and what isn't. Okay. So before 1926, and every year after, we're going to have, like, next year, it's going to be before 1927. So big party. Those things fall into the public domain. But if something was published 1926 through 1977 without a copyright notice, so okay, so think about this, the C with the circle plus the year plus the entity that owns the copyright. If it isn't on there on a work that was published between 1926 and 1977, that work is in the public domain, because these were called formalities and you had to have complied with these formalities. They were required at the time. They're no longer required, but they were under the law at that time. Similarly, you've got between 78 and 89, it's published without notice and without subsequent registration after 5 years. Okay, that's in the public domain too. This requires a lot of research. Seeing if there's a notice doesn't require so much research, but this registration work can be a lot, and we'll talk about that in a bit. 78 to 89, you know, again, these changes in the law are coming into play. So published without notice, but with subsequent registration within the 70 years, then it's the life of the author plus 70 years like it is now. Or for, you know, work for hire, you've got longer. 1926 through 1963, if it was published with a copyright notice, but the copyright was registered, but the copyright was not renewed, it's in the public domain. This works in our advantage. 1926 to 63, published with notice and the copyright was renewed. It's still under copyright to this day, 95 years after the publication date. And of course, 64 through 77, published with notice. It's, still, so you've got all these kinds of conditions that go along with when things were published that you have to kind of keep in mind and coordinate. Peter Hurdle, as I said, is not a lawyer, but and he's actually retired now. I'm not sure who's going to take it over at Columbia University to update it, but he always said, look, if you notice a loophole or something confusing about this chart, let me know and I will make a change to make it more clear. So if you do go and look at this chart, you will see that it's footnoted within inches of its life. And they're good footnotes. They're not terrible footnotes. They're helpful footnotes. It's very hard to distill the law down into a simple chart because it is so complex. So, don't be afraid to be afraid, or don't feel stupid to feel like you don't understand it, because it is terribly complex and it takes people years, and experts like Peter Hurdle are, sometimes flummoxed. How do I get this concept across? Okay, so go ahead to the next slide. First of all, there's the idea of publication, the definition of publication in the legal sense. What is publication? Not explicitly defined in the copyright law before 1976. So Peter Hurdle notes that in the 1909 Copyright Act indirectly indicated the publication was when copies of the first authorized edition were placed on sale, sold, or publicly distributed by the proprietor of the copyright under his authority. And of course, they had this gendered language at the time. So anyway, that bugs me, but you can't do much about what the quote says. Anyway, but this gets confusing, because what if you put an ETD up on the web? Is it published? Well, you didn't really distribute it. You made it available. So does it meet the definition of publication? These are things that are questions. It's also important to note that not all published works are copyrighted. Okay, so you've got a published work done by guess who, the federal government or maybe a state government. Maybe it's not under copyright at all. There are 20th century formalities. Okay, some books had to be printed in the US at some point to receive copyright protection. So those that were not during that time are in the public domain. How do you research that? That's tricky, and that takes a lot of digging. A failure to deposit a copy with the Register of Copyright. So when you go to register your copyright, you didn't attach a copy to go into the Library of Congress. Well, that could result in loss of copyright in some cases at some point during the 20th century. So, think probably more is in the public domain than we realize, because to do this kind of research would take like a lot. Requirements, the copies include a formal notice of copyright and the copyright to be renewed after 28 years were the most common conditions. So this is what we really focus on. Okay, next slide. So this is the ARL Code of Best Practices. And the code is on the web, available. You can download it in a PDF. You can order copies if you like a copy. You can print it out. Code of Best Practices and fair use for academic and research libraries. So we leaned on this. And if you look at the chapter, Creating Digital Collections and collections of archival and special collections materials, you've got all these phrases that I thought really applied to what we were doing. They were published and unpublished, this mix match of goodness knows who what. Copyright status is often unclear. No kidding. Was this published? Does taking a pamphlet saying support Kent State and distributing it on campus, does that equal publication? Hard to know. These were materials that only could be consulted on site. Now, mind you, the grant request was written in 2015 or something, so way ahead of the 50th anniversary of the May 4th shootings, also way ahead of COVID. But think about this. COVID came, we were all stuck in our institutions. We couldn't travel. Some places were not open. Consulting only on site became a real barrier to that. So thank goodness we wrote this grant. Thank goodness we did what we did, because for the 50th anniversary, so much had to be done so that people could get at the information that they could only otherwise access on site. So this was really not a very happy coincidence, but a coincidence that benefited us. Again, a unique assemblage or aggregation. Who else is going to have what we had because we called for all this information to be sent to Kent State? And it was organized around a key topic, area, or theme, certainly. And presenting these unique collections as a digital aggregate, especially with commentary, criticism, other curation, could be highly transformative. And we did curate it. There were things we made decisions about. What do we digitize? How do we do it? How do we display it? So again, Kenny Cruz Ferry's checklist. I'm a big fan. I love him. Here's like the love sign because I love him so much. Just to remind you about that checklist, you can go ahead to the next slide. Then, okay, so this is where Jenny takes back over again. So
It is. Sorry, I was scrambling for my mute button. Hopefully my audio is okay too. I brought a headset, but hopefully it's good. All right, so I wanted to talk a little bit about selection and copyright. As Cindy and I were putting this together, I was really thinking a lot about, the work that I've done here at a public state academic institution since 2014, and previous to that at a private academic, and before that at a state museum. And I really thought about kind of the differences on all of these institutions around selection, copyright, risk tolerance. But I think the one thing I just kind of wanted to, quickly mention here is that selection often balances so many different factors, the usage and interest of the material that you're looking to digitize, perhaps the condition is a factor. Copyright, I think, has been a huge issue from my experience. I think the previous institutions I was at, we definitely tiptoed around copyright because we did not have a Cindy Kristoff to help us find those waters to go through together. And I love this. I don't know if any of you are fans of New York Public Library. They have these little labs they do, and they had one a few years ago, was visualizing the public domain. So most oftentimes in digital projects, out of copyright works are chosen because it's just the easier pick. So now there is kind of this mountain of material because we don't want to deal with the kind of murkier waters of things that are in copyright. But as I said before, I think I'm less scared now than I was when I first started at Kent. So thank you to Cindy. It definitely helps having someone in-house, although that's not always the case at every institution. So you may really need to, find somebody in the network. There's, if you're in Ohio, there's some really great folks at the Ohio Digital Network if you're looking to include content into DPLA. But definitely, I think, finding folks that you can ask, whether it's a copyright person or general counsel, is definitely recommended. So institutions and risk tolerance. Has your institutions had conversations around risk tolerance and copyright? I've been at institutions where the approach was, we'll just put it online until somebody asks us to take it down. That's certainly one approach. But I've felt very fortunate to both have Cindy and also some really great resources and general counsel to really help guide some of those murkier questions. As I was looking around to put stuff together for this presentation, I found this great presentation from a few years back. There's a link later in our references, but there's some folks that talked about assessing copyright risk tolerance for large scale digitization projects. So they came up, it reminded me of the fair use template, but it was really kind of working through item by item, thinking about copyright restrictions, license, the amount copied, which one of our examples later with the grant project, we'll talk about amount. And these are things, you could retain, for later to kind of check back your notes on, why maybe you did take a risk for X, Y, and Z. But I think it's important to have these kind of conversations. They aren't necessarily fun ones, but I think it's really good practice to kind of get these kind of incorporated into digital projects and where your institution may land with some of these questions. So preservation scanning, I'll just spend a couple moments on this too. So this is really the idea of if you absolutely don't have the rights to publish something in its entirety online, you can create a high quality digital file to keep offline. Most oftentimes this is referred to as a dark archive. We've also got offline storage. This is a place that practitioners could access, but that the public would not. We've used this in certain departments where we have high-res images that we can't include in our digital repository, but that we can use for individual patron requests. There's also an approach of enforcing an embargo on certain content. I see this most often with the theses and dissertation. If you're here in Ohio, OhioLink has a really nice tool for setting embargoes, if that's applicable to the material. And then I saw there's been a couple universities that have done these kind of creative virtual reading rooms. So mostly special collections and archives based, but it's creating this kind of restricted virtual space. You can't download anything, it's just viewing, but kind of again, the idea of creating these really high quality digital files that you might not be able to share out, but that people have gotten kind of creative with how they can still deliver these, especially in this post, in this pandemic era where we can't visit these places on site. So now I thought it would move to the last 20. I know Cindy did a little mention of this morning, but we'll talk a little bit more about that now. So the last 20 refers to a really specific section of the US Copyright Code, limitations on exclusive rights, reproduction by the libraries and archives. So it's my emphasis on this piece that I pulled out, but I'll read it here. During the last 20 years of any term of copyright of a published work, so Cindy had talked a little bit about what publish means, libraries or archives may reproduce, distribute, display, or perform in facsimile or digital form a copy or phonorecord of such work or portions for the purposes of preservation, scholarship, and research. So the ones I emphasized, I really think to me are kind of the most meaningful and how we can kind of think about this and apply this to digital libraries. Because I think these, if you look at it under that preservation, scholarship, and research lens, especially, that could mean a whole lot of things. So as of January 1st of this year, this window of the last 20 could be works from 1927 to 1946. And I'll talk a little bit more about that. First, a couple exceptions. So the work is subject to normal commercial exploitation. So there is a little bit of research you'd have to do to make sure this is not an item that would, if you made freely available, would impact the market. A copy or phonorecord of the copy may be obtained at a reasonable price. I've always thought reasonable price is kind of an interesting term because that could mean different things to different folks. The copyright owner or its agents provides notice pursuant to regulations as set forth above. And then they also exclude musical works, artistic works, motion pictures, and other AV materials. So we've really looked at this, at least here at Kent, mostly on printed published materials. So how do you go about identifying this? I thought this might be special interest to this group, but we ran a unique holdings list on our catalog, filtering by those publication dates that I gave before. We did this a few years ago, so our dates were a little different then. We initially had some issues determining unique titles. There are a couple different issues, I believe. I think our catalogers would know more about this, but I think it had to do with both having branch collections and regionals in our catalog too. And we were kind of, for this project, at least really focusing on our main collection titles. So one of our catalogers turned to OCLC to ask them to run another report, which actually proved to be much more valuable for our group. We thought it was more accurate when we compared the two lists, and we thought better reflected the unique holdings at Kent State. So from this list, we looked at the titles and we wanted to really start thinking about the following questions: are these orphan works, which I think Cindy talked about this morning as well? Are these titles that would not be impacted commercially if digitally reproduced? And would circulation information be helpful here to identify titles of special interest? So if this is a title that has been, has a lot of checkouts, that kind of tells us that there is interest versus one that without, that might go towards the top of the pile. So the next steps we did was, well, we haven't gotten there yet, but once we looked at the list of selected titles, our next step would be to look to see if they're in digital form elsewhere. HathiTrust and Google Books are probably the top two. There's certainly others that would be good to check. Just make sure that work hasn't already been done yet on these titles. So I had a graphic. I think one of our cataloger colleagues here at Kent put this together. So it was a graph of all the items published in our catalog from 1085 to 2020. So the red circle in the middle, that's that sliver of the last 20 titles. And I think I've got some numbers on that here in just a minute, but the piece that we haven't got to yet, mostly with COVID and staffing and not having student workers, is pulling these titles and inserting them into our production workflow for digitization. I think this kind of project could be a great kind of back burner project. If there's time or resources to kind of keep plugging away at this, I think this is a really fantastic one. So now we'll turn a little bit more towards project management. Cindy, you mentioned we've had a couple grants over the years with our May 4 collection. We've got an NHPRC grant in 2016 that ran 2 years that we digitized roughly 50,000 pages from our May 4 archival collection. It's over 300 cubic feet, I think over 100 sub-collections. So we digitized roughly about 40 of these sub-collections, mostly documents. And then we also had just recently wrapped up a Clear Recordings at Risk grant as well. So we thought we'd share a couple notes on how we did some project tracking with copyright. Good old Google Drive. We sorted these by sub-collections, and we did a lot of the fair use analysis that Cindy talked about. But we really wanted to have these somewhere where it wasn't just one person had access on their desktop. We wanted this to be someplace shareable and someplace too that, if asked later, there'd be a number of us on the project that could access these fair use analyses. Cindy will talk in a few minutes about our Sanborn digitization project, but this is a big one from our map library. Also used the Google Drive suite to use for individual item level copyright review. Nothing terribly exciting to look at other than we had multiple people on the project and trying to do different pieces of the project, which Cindy will talk about a little bit more in depth in one of our examples in just a couple minutes. And then on a systems end, we did for our special collections and archives, is hosted on Omeka. So the May 4 project, I can put a link in the chat later, is all through our Omeka site. It's an open source digital platform. The really nice thing about it is you can really put in these kind of small adaptations to a project that were really helpful. So here we had a permissions field. So we added this copyright review, NHPRC, as a category there, so you could pull up by sub-collection and then also what items remain to be reviewed. And then once that was reviewed, we'd move that to cleared, and our production manager could publish that online. But it saved a lot of time. We probably could have done that in a spreadsheet, but it just was nicer to have this on our digital platform interface, I think for those of us who are working on permissions. The Sanborn one, I think we wanted to show an example of our rights statements. Cindy, do you want to talk about rights statements a bit?
Oh, I was muted. That's not good. Okay, so I mentioned them in the last slideshow and earlier today, but we did apply standardized rights statements to actually the NHPRC project too. We put that everything was in copyright. That was kind of a blanket sort of thing because there was such a mishmash item by item. So, on the safe side, we did that. For Sanborn, I'm running into things that either I don't think are under copyright anymore or are clearly still under copyright. So there have been basically two that I've been working with, and I created some simplified rights language that would go above the rights statement so that people can go and click on the whole big rights statement if they want to, but they've just got this general idea. And of course, it's on the user to do what they do with it. Okay, so this example was from the NHPRC grant. These were newspaper clippings. I probably many of you are old enough to remember that when people used to send letters, remember those, and they would include newspaper clippings with those letters. Sometimes they would just clip out the newspaper clipping and then underline certain parts that they wanted you to see. I wonder if some point somebody is going to be interested in what those underlined phrases were. And in fact, when I examined those pieces, I thought, wow, what they're underlining are issues that we're running up against today, things that are talked about in the media. And so that was very, very interesting to me. So I thought that, anything like this that had been altered like that, along with the letter that it came with, was very much a fair use of that kind of material. And I tried to include where there were underlinings made. There were plenty of clippings where there was not that. But I will also say about newspaper clippings that we also maintain relationships with our local newspapers. So we've got the oh no, the Record Courier, which is Portage County, which includes Kent, Ohio. Then we've got the Akron Beacon Journal. I don't subscribe to the Record Courier, so sorry. Akron Beacon Journal in Akron, of course. And then we've got the Cleveland Plain Dealer. So we knew that with the 50th anniversary of May 4th coming up, and just the coverage and relations with the university, we wanted to maintain good relations with them. What we did was we contacted them and said, we're doing this project and we would like to include newspaper clippings, assorted ones from, back in the day. Some of them are underlined. May we have blanket permission for that? And we thought, this is good because we want to keep this ongoing communication going, know that we're thinking about them. They're going to be thinking about us when they cover us. So it was more about a relationship than it was really about copyright. But as it stood, these were like, Record Courier was privately owned when we made this contact, and now it's owned by a big conglomerate. So, I mean, we have the blanket permission. We have that letter stating that we have it. The Plain Dealer, what the Plain Dealer wanted to know is if we use an article, just let them know because they keep statistics. So we were very interested in maintaining relationships. So it wasn't just about the copyright with many of these, and we did license some out. You should know that if you do this type of work, if you try to license out an article, they're like, well, how long are you going to well, this is a digital archive, we're keeping it up there forever and ever. And a lot of times they don't have that concept of forever and ever. They've got like 20 years in their head, or maybe at the maximum. So I think lately, though, they're beginning to adapt to that and know that there are projects like this going on that we do want to license and pursue permissions. This is another example. The campus strike papers were such an assorted mass of creativity and originality, and some things were just copied from other sources that we didn't know, probably other campus newspapers or a local newspaper, and we're talking about all over the country. So this is an example from Northwestern University campus strike vote poster that was created May 5th, vote to strike. There was this mass meeting. This cartoon of Uncle Sam is on there. Highly creative, highly, who's the copyright? Who was the creator? If they left a signature, it would sometimes be a little scribble. You know how artists can be, those artists. Other times, it was there was nothing to go on. So what we did for most of these was we invoked fair use. And we said, we are creating this unique collection that really isn't available anywhere else, and one that you would have to be on campus to examine. So this is something we wanted to preserve too. These items are beginning to get a little bit old, get a little crumbly. So part of that was our point too. So yeah, we invoked fair use. This is another example. This was a commemoration called Simple Gestures, and this was an installation done for the 1995 commemoration of May 4th. And this was kind of based on, they tried to bury us, they didn't know we were seeds. What they did was they got custom made seed packets. Whoever coordinated this was just brilliant. I thought they got these custom made seed packets, different colors, different flowers. And we wanted to digitize these seed packets so that, we could show what the choice was for, you'll see that in a second, show what students could choose from when they posted these. And so we knew these were copyrighted. The company is long gone. We don't know who printed them. Certainly this is, creative. It certainly is, but, is it terribly copyrightable, or is it kind of like this standard fact based? I mean, there was just so many things ran through our minds. So we did end up invoking fair use because we could not contact the company who originally published them. Next slide. However, there were other things included when people worked on this installation. This was a poem by Gary Geddes. He wrote this about Allison. No, not about Allison, about Sandra Schuer. And this is a poem he wrote about her. And he is actually he's got a website of his own. And we found it on this Canadian Poetry. So after finding him, I thought we better ask him if we can repost this poem as part of the Simple Gestures installation that was done in '95 that he probably had no idea about. This guy was so excited. He was like, yes, of course you can use this. And he said, I want to come and read my poem at the 50th commemoration. And I said, well, I'm really sorry, but I'm not in charge of that part. This is something that I can pass along to the people who are in charge of it. But, it's not something, it couldn't be a quid pro quo where you could post this if I could come read my poem. So we did secure permission from him. And so for poems like this, something highly creative that we could find the person, we did ask for permission. Next slide. And this is the installation. This is how it looked. So you can see where people posted seed packets along with their thoughts about May 4th. So all along the table where the little stools are, you had the seed packets you could choose from, and then little cards upon which you could write your thoughts. You could write a poem. You could bring a poem with you, like the one student did who posted the Geddes poem. And then it became this big, kind of display installation that certainly is not available now, but the pictures are, and we wanted to remember that. This was a tough one. George Siegel. KSU commissioned a sculpture to commemorate the May 4th shootings. And George Siegel was a famous artist who was at Princeton. And he created what he called the Abraham and Isaac sculpture. Those of you who know the story of Abraham and Isaac in the Bible, this was like a sacrifice. So what you have is a soldier and you have a student on his knees with his hands tied. And it was a very, very compelling kind of sculpture, but it was something that when the university officials saw it, they thought, no, we can't put this up because what are parents going to say when they see this? It's not going to be good for recruitment. It was terribly, terribly controversial. And George Siegel's feelings were hurt. There was a lot of work that went on behind this. We wanted to include the work, the art that went behind this, include the endeavor. George Siegel had an estate. So you can go to the next slide. And this was something that we found using the Harry Ransom watch file. We were able to find who takes care of his estate. That ended up being the Artists' Rights Society. So we emailed them and said, we would like to put up all this George Siegel stuff. And, I don't think that George Siegel is no longer around. I'm not sure he would have let us, where he's still alive, put this stuff up. The person who handled the copyright at the Artists' Rights Society was not familiar with this controversy. We paid a small fee. It wasn't that huge, but we put up all of the George Siegel materials. Go to the next slide. And so that was a good thing. I thought I had one more slide on George Siegel, but I guess I didn't. But yeah, that was a really tough one. Right now, the George Siegel sculpture is at Princeton, where George Siegel was. So it can still be seen, but it's not being used as part of any kind of May 4th. And that's what this picture is of. I think it was Nancy Burke who took that photo when she was at Princeton. In the rain. It is really, it's very emotional, and people get really emotional about this still. Okay. Next, I want to talk about an example of the Sanborn maps. You know, we talk about how the law, now these Sanborn maps were, goodness, early 20th century through about the 1950s. And most of these in our collection were from the local area. Jenny might be able to fill you in more on the scope of the collection.
Yeah, I think the dates ran 1880 to early 1950s was the most recent one in our collection. Kent State ended up being the holding institution for the Sanborn fire insurance maps. This was a second copy from Library of Congress. This one, whenever I talk to the current map librarian or a previous one, they're like, it's kind of a hidden gem. Like these weren't cataloged if you didn't know they were there. It's really just kind of circumstance, I think, the folks that do come in and use them. So we got a Ohio History Grant and an Ohio Local History Alliance grant to digitize all of these. I think there were like 23,000 that we sent out to Backstage Library Works. They did a fantastic job. It's been, I don't know, 3 years, I think, that we've been working on this project. So right after the first of the year, we've gotten, I'd say, the majority of these up online, with the exception of the ones that are in copyright. That Cindy can talk to a little bit more about that process.
So a little bit about this copyright, you know, remember from Peter Hurdle's chart, and there are some other sources you can use too, especially with Sanborn maps that you can look at if you want to discover copyright status. But, you know, the first thing you have to look for is that copyright statement. If the copyright statement appears in the piece, then you have to keep doing some searching. The copyright statements on some of the Sanborn maps are really small. And in this case, this is, I think, Cleveland, like Lakewood-ish area. And the copyright statement appears under the scale, 50 feet to 1 inch. Okay, so this tiny little copyright statement. Okay, so if it's got a copyright statement, you've got to keep looking. If there's no copyright statement, you don't have to keep looking. But you got to know that you might miss the copyright statement because it can be so teeny weeny. So the next slide should have a normal sized copyright statement along with the seal. So here's Buckeye Lake Park, very popular when I was a child in Licking County. And so you see the copyright statement pretty clearly in this nice little seal. And I don't know what was behind these seals, why they included some of them, why they didn't. It's hard to know. I don't necessarily find a correlation between these statements and what got registered for copyright. But, you know, the minute you see that statement, you've got to do some more searching. If between this time period, if you don't see a copyright statement, it's in the public domain, and you can go ahead and assign it the right statement of out of copyright. That's what we're doing to the best of our ability. You know, to the best of our ability, these are not under copyright. Okay, so next one. What I was talking about with the outline for how to determine copyright on Sanborn maps, George Smathers Library at the University of Florida has a really great lib answer that outlines the process. I've been using not just looking for the copyright statement, but then if it's there, checking the catalog of copyright entries. So if you remember, if it was registered for copyright, it had to have been renewed to still be protected by copyright. So you have to look for the copyright registration. If there's no copyright registration, even though there's the statement, we're putting it up, public domain. Was the Sanborn, what I do is I search the year of the map, and then I search the year after the map. And if I'm going to find it, I find it either the year of the map or the year after the map. And I was surprised at how many copyright registrations, I found that like the year of the map was 1926, but then the year of registration, it appeared in the 1927 catalog of copyright entries. So that was a shock to me. So if I find it in that registered, I look to see if it was renewed. So what do you do for that? Well, you add 28 to the year. And then I try to look at the years surrounding, 2 to 3 years, and then surrounding to see if it was renewed. And if it wasn't renewed, public domain. It's a challenge. This can be a slow process because it can be slow searching all these servers. The University of Pennsylvania has this nice index of the catalog of copyright entries, so that all you have to do is click and you get right to the renewals, or you get right to the registrations for that year. So like maps are sorted in with pamphlets and that sort of thing. So you don't need to look at the whole big book, but you do. If you use this index, then you can find what you're looking for relatively quickly. The UPenn Catalog of Copyright Entry Index goes to 1 of 3 places. The Hathi Trust, which is my favorite place for it to go. I like the Hathi Trust. I love the layout. It makes it easy to read. It reminds me of the old days of, having to look at print indexes. Boy, I feel old some days. So Hathi Trust is terrific. The Internet Archive also has some of them, and the Internet Archive is so-so. The Internet Archive server can be really slow sometimes. So what I've done is downloaded a lot of the catalog of copyright sections just for my use, so that, I know I don't have to go to the Internet Archive when I look for those particular years. So right now, the things that I'm working on are mostly in the 20s, which would have been renewed in the 50s. So those are the ones I'm working with. The Google Books catalog of copyright entries are not fun. I don't like their layout. I don't like their search interface. I don't like them, and I don't like them. Did I say I didn't like them? So I prefer to work with whatever's on Hathi Trust or on Internet Archive. Google does a great job for some things, but not for this.
All right, and then I think this was mine. So AV materials, actually, I think today was our deadline wrapping our Clear Recordings at Risk grant. This was 400 very odd items from our Special Collections and Archives May 4 collection. We essentially pulled everything from the 300 plus cubic feet that we couldn't do in-house or couldn't do in-house easily. So we had Betamax, Umatic, we had, I'm trying to remember, we had a couple really obscure, Cindy, do you remember it was like the dictation tapes? I can't remember those Magna belts. It was just this really funny kind of hodgepodge, and copyright was an issue, I'd say by and large, for the majority of the stuff that we sent out. We had a vendor in the Philadelphia area that did the digitization, and once that came back, we started doing a copyright review on an individual item. Some of these were event recordings from commemorations. I think one of my favorites, just because I was there when I was, 15 or 16, it was the 1995 commemoration that Peter, Paul, Mary played at. So we looked at licensing for the Peter, Paul, Mary songs and found that I think 2 of the 6 songs they performed were not theirs. One was a Bob Dylan song and the other was a Woody Guthrie. So after a lot of debate on, could we edit these down into single songs, because Peter, Paul, Mary had given us permission to post the recordings of their content. I think in the end, we decided we're going to restrict access to the digital file, but we'll have the record there so the folks can contact Special Collections if they'd want to access that video file. We had some radio broadcasts that were really interesting. I think the majority of those were from WKSU, which is here on campus. They were very nice to work with permissions. A lot of them were short clips, so I don't think that had been a big issue. And then we had, I think I lumped these under personal recordings, just very odd recordings that were in different sub-collections. I think we had one that from our understanding had been kind of recorded without permission in a hallway or some sort of group setting. So that we had kind of a lot of different issues on this kind of assortment of audiovisual, but we looked at fair use for some of them. We did the permission seeking. We did look into state laws around consent around audio recordings. In the state of Ohio, you only have to have one person who knows that they're being recorded. So legally we could post this item, although I think ethically we decided we were not, because it just was kind of an uncomfortable item. But I think, I don't know, Cindy and I feel like the AV content, this was really, some of them were really a struggle because there were so many layers of both the recorded content. And then I was thinking about the 17 magazine item. Cindy, do you remember
When
that
I was most interested in, it was 17 magazine who joined up with MTV. And I would love to have that on there, but my gosh, you know, there are so many copyright owners, and are they going to talk to us, and are they even going to give us a time of day? No, they don't. There was another that was ABC recording. There was an interview, and it was terribly good. It was with Alan Canfora, who recently passed away. And it was an excellent interview, but it was, you know, ABC is now owned by Disney. Disney wasn't going to give me the time of day. Do we put those things up under fair use? I don't know. I mean, so we did not for those two things. We figure we can give somebody a link if they ask for it, if they happen to be off campus, but we didn't put those up. Whereas like sometimes like there would be a local band playing on the green, and there would be students, and there would be kind of like not so much a focus on the music, but a focus on just the experience of being out in this crowd. And there were a couple of those that I did say, let's put them up. And we put them up. There wasn't anything embarrassing in them, you know, for people. It was just a scene of a crowd like you would see on a college campus, you know, wonderful spring day and music being played in the background. So we hope we did the right thing.
We have not had any takedown requests yet, but it's still, we're just probably about a year into when we published our first items from that too. But that was, for me, a big learning experience. I've not worked with AV copyright before. I think that's the end of our examples. We wanted to leave a lot of time definitely for questions, but we also would kind of invite folks to, you know, do you have something specific in mind that's really kind of left you puzzled that you'd like to talk out, or, you know, just kind of throw out? I think Cindy and I are definitely happy to see if we can be of help.
So we do have a lot of questions, and there is one pretty long and involved, like a what would you do kind of discussion. So I thought we could end with that one and go through some of the more basic questions first, if that works for both of you.
Sounds good.
Okay. So the first question was, what if you seek permission and don't receive a response at all?
So we nagged them a couple times. And if we didn't receive a response, we sent it back to the fair use. And a lot of times these were the ones that we sat around the table and discussed.
I think on our NHPRC one, we do what, 3 requests over about 3 months roughly to say a reminder. And if they hadn't responded by the 3rd request, we thought, well, we've done our due diligence.
Some cases we decided not to put it up, and in other cases we put it up.
Okay. This is kind of a 2-part question. The first part is an original work of art, such as a painting, considered to be published?
You know something, I didn't consider it to be unpublished in terms of evaluating for copyright. I treated that like an unpublished, still under copyright, still has commercial potential. Did they publish it? Well, did it get put in an art catalog? Well, maybe it might have. We don't know really. You know, I guess that's not a question I struggled with, because most of this art was local art that, yes, it probably had been published and put in a book at some point. There were several books on May 4th. I took it as an unpublished and went from there and tried to seek permission.
Okay, so the kind of related question to that is, if a photograph was published in a newspaper between 1926 and 77, would it have to have the copyright notice on the page or the image to be in copyright today?
My take on that was if the newspapers were copyrighted, then the newspapers were copyrighted and that image became part of the whole. So frequently you would find a newspaper article with an accompanying image, the image that was in the newspaper. And so for those, we took the permission of the paper. Now, having said that, there were several people, like local people like John Philo or Howard Ruffner and Chuck Ayers, a lot of people that were local photographers who were students at the time at Kent State, who snapped photographers, or they were working for local papers at the time. And if we happened to use their photograph out of the context of the a newspaper article, we treated it as unpublished and pursued permissions. And part of this is what I was talking about with the relationships. We've got ongoing relationships with John Philo and with Howard Ruffner and with Chuck Ayers and all these people that, and I don't even have the best relationships with them. It's other people that really knew them back when. And, we want to maintain that kind of good relationship where we touch base and they know we're doing things. John Philo, that famous photograph of Marion Vecchio standing over the body of Jeffrey Miller, you can find it just about everywhere, including on Facebook. It's been made into memes. And John Philo doesn't really enforce his copyright with that. He lets people make memes. It gets reprinted all the time. I'm sure it gets evaluated for fair use. He's not a terribly aggressive enforcer of that. However, there are some photographs of John Philo's that were submitted by Howard Ruffner to Getty Images, so Getty Images could work on distributing them. We don't know what the agreement was between Howard Ruffner and Getty Images, whether Howard Ruffner is allowed to give his own permission for the images he sent over to Getty. We don't know what that is, but we have asked Howard Ruffner for permission and he has granted it. Whether he has legal standing to do that, we do not know. So you can see where there's so much mushy gray area. And all we do is try to maintain the relationships and do the best we can. If it's not a replacement for the original image, if it's a very obscured kind of photograph of, we treat it like we would a thumbnail and think of it as fair use. So it's really a mix of a lot of things.
And I think we did do more permission seeking with May 4 because it is such a sensitive topic. So many, I think, still, hard feelings between the students that were there that day, the university. So I think we were probably more cautious on that than other projects too.
Okay. This one is kind of open to everybody, so I'm going to ask y'all, but if anyone wants to chime up in the chat, feel free as well. Besides an outright takedown request, has anyone else experienced name redaction requests? And if so, how have you typically dealt with those?
I know we've gotten some for our digital student newspaper, and this has been a big, exciting topic for me because that whole right to be forgotten in the EU of kind of a right to take down a personal name, I think is super interesting. So we've got a really good relationship with our student media office. We were really, we reached out to them for the newspaper requests to get their input, but since they are, the current editors of the newspaper, we wanted to get their thoughts. I think to date, we've kept all of them. We did get general counsel involved. Cindy, I was trying to remember if we've had anything else that wasn't the stater with names.
Yeah, we've had like I think there was maybe it was just the stater. I was thinking that maybe the bird, the yearbook was involved too. But really, we've had a couple, we had an instance where a student's photographs were included and they were part of a newspaper article that was, submitted to the Daily Kent Stater. The Daily Kent Stater has kind of two models for getting information into the paper. One of them is work for hire. You can work for the Stater and get a little stipend. We consider that a work for hire. There are other times when the student was contributing to the paper as part of their coursework. And of course, students own the copyright to their own coursework by university policy. So that's really, and we don't know which is which when we're archiving. So we do look to, fair use. We look to the copyright that the university has in its own publications. And, we did that as a guide, but we did get one kind of a request, and it wasn't really takedown. It was more of a let's strike a deal kind of thing, because this person was now a professional photographer in a city, not a well-known person, not, but she was like, well, these are photographs that I took, when I went to this volleyball game, and, how can we monetize this? I think it was not so much a take down, but a different kind of request. And, those are troubling, because, we want people to earn money, but, we want to share the work more widely and also preserve it as well.
Okay, I've got 2 more of the short questions and then about 3 long form ones. So I hope we have time in the next 15 minutes. So the next one is, are the Google Drive products that you use for copyright tracking institutionally backed, or is it shared on personal accounts?
That's a good question. So we use our Kent State Google Drive, although we did have, I think we had some issues from time to time with students accessing Google Drive too. But yeah, we kept everything on our Kent State one. And I know there's definitely some security issues with Google that some folks might be concerned with.
Okay. Do you do anything through Content DM? Why or why not?
We do not. I think when I came on board in 2014, they had kind of a homegrown digital platform for special collections and archives that's now Omeka, which is open source. And then our institutional repository is on Islandora, which is also open source. I think it's just because we have in-house developers to kind of help maintain both of those platforms. We have used Internet Archive. And then for newspaper, we use Veridian, which is a subscription service just for digital newspaper. As for the why not, I guess I don't have a good answer for the why not, other than the stuff we have so far has worked pretty well.
Okay, so these next couple of questions are pretty long, so I'm going to post them in the chat so that y'all can both refer to them if you want to, but I'll read them for accessibility's sake as well. So the first question that came through privately was, I have uploaded several Park District scrapbooks onto our local history site because I thought they would be under the umbrella term of fair use. Now I'm not so sure. Some of these scrapbooks have articles published after 1977, and some articles are from newspapers that still exist. Do I need to take these down? Do I need to try and contact the Chicago Tribune and get permission to keep these articles in our collection?
I think, first of all, remember that fair use is used for things that are still under copyright. And fair use is a doctrine that allows you to use something that's still under copyright without first seeking permission. I considered a lot of the newspaper clippings to be small portions. Again, if the context, and I wrestled with this, believe me, I asked Kenneth Cruz at a conference. That's how much I was wrestling with it. Kenneth Cruz gave me some enlightening tips, and he said if it's a scrapbook kind of thing, wherein you've got a local picture, a local story, the newspaper clipping, where these things are presented together in a way in which the copyright owner would not present them, you've got a possible case of transformative fair use where you're pairing something up with something that would not exist otherwise. You have this very unique collection, this scrapbook that's very local, where you have these 2 things or 3 things, 4 things juxtaposed. And can you make a fair use argument around that? Well, yeah, you sure can, because this is taking this piece, putting it with this piece, and allowing people to see them as a whole. So try to think about it that way. I wouldn't worry so much about permissions at this point. You've got it up. You can probably still have a very, very good case for, this local history that may not otherwise be easily accessible. I hope that helps.
And I think Ohio State just put a couple scrapbooks up that kind of reminded me of the similar, I can't remember if Backstage did the digitization, but they had a really good webinar kind of addressing it, but a lot of the same things that we thought about the newspaper clippings for sure.
Okay, next question. The editor of our small local newspaper gave us permission to add issues to our local history site, even from 2021. Should I be worried that the individual creators of the articles and photographs might request we take their articles down? You mentioned that authors often relinquish their copyright to their publishers. Is that common?
So this actually, there was a court case about this when newspapers started being digitized, and there were some contracts that some authors had with some, well, and photographers too, where they retained the copyright to their works and the newspaper didn't own the copyright to give them permission. That's a very important concept, that the person who gives you permission actually owns the copyright. And if they don't, well, you know, somebody who doesn't own the copyright cannot sue either. So this is a very important legal concept. The fact is, you don't know, and you're working on what I would call a good faith basis. You know, the paper is in good faith saying, we think we own the copyright, we're going to give you permission. The person who works with the paper may not know. It depends on the employee contract. So there's so many different moving pieces here. I wouldn't take it down. I wouldn't say that that permission is invalid. You were working within, you know, the best of your knowledge. And if you later find out something else, then you can make another decision, perhaps fair use.
Okay. If we are adding in local newspapers, should we not add in the police reports of the paper that may give someone's name and general address?
So I can say that that's been the majority of our takedown requests was from the police blotter section of the Daily Kent Stater. We talked a lot with the folks at the Kent Stater about this. They were really adamant that, you know, the information had been vetted, that it was true, even if it is, you know, damaging to a person. And they were really, I think, pretty adamant about including it, even if folks will be upset. But it's a really tricky topic because we're also, a lot of times these are our alums that we're, you know, upsetting with these kind of decisions. So I don't, Cindy, what do you feel about that?
You know, I have so many mixed feelings. This is that right to be forgotten that Jenny loves this topic. And in Europe, the law is a little different than here in America. You know, in Europe, the law is more towards the individual. Whereas the law here is more towards the community being able to know about something. So it's really interesting, the contrast in the law. And I think maybe we'll see more legal things go through our courts, and, you know, maybe we'll see some legislation. I don't know. We may not. It's interesting how, you know, both Europe and the United States are interested in freedom, but the different kinds of freedom that they're interested in. And we're really more about the First Amendment. So yeah, it can be a really hard decision. And I think if there's a lot of pushback, you know, people looking for jobs will search themselves on Google to see if there is anything like that, and if they're nervous about it. I mean, that's a really tough decision, and it's definitely not something that you can take lightly, something that should probably be discussed at a high level even.
Yeah, in the EU, they have, it's not a rigid date, but it's kind of this concept that after a certain amount of time, there should be kind of this notion of kind of forgiveness and programmable forgetfulness of saying, you know, this arrest report from 1986 is no longer relevant today. So for this person who's not in public office or not, you know, celebrity, they'll grant this. The kind of condition there is that it's being taken out of search results and not the kind of actual item. So you could still find it, but just not through, you know, a Google search. But Cindy and I did a whole paper on it. That's my, I don't know, my rabbit hole that I could probably talk way too much about. But it's a tough one. There's been a court case in the US, I think, that landed very differently than the one in the EU on very similar, you know, it was just the individual requesting to have their name taken out. So yeah, it's tough.
Okay, I've got one more longer question that I'm going to put in the chat and then read, and then a few short ones. So hopefully we can get through those by 3. Next one is, I inherited a newspaper project where the library director had student workers cutting out articles from newspapers that mention the college. I would like to digitize these clippings. Do I need to ask permission of all the different newspapers involved and or ask permission for each article? If I choose to digitize the clipping but not make them public, do I still need to ask for permission?
This is tough because, you know, if you're creating clippings, you know, out of whole cloth rather than, I don't know, kind of digitizing a scrapbook, you know, it may be kind of a different thing. I mean, really what you're doing is like almost like a bibliography sort of thing where, you know, you're putting together. So I think it, you know, it includes what else is going in with the newspapers. How will it be used? Will it be used to answer reference questions, or, you know, do you want this on a website that's available to the whole public? There are so many different factors involved with it. I think that, you know, that's a tough one. I think it really depends. I hate to say that, I know, but I I think it's easier when you've got other materials in the mix. Like you've got this piece of art and here's, you know, an article, then you've got more of the scrapbook effect.
Jenny, did you have anything to add about that one? No? Okay. So the last questions are related to the Sanborn project. How do you know who to contact about copyright with a company like Sanborn?
I could not wait to answer this because I saw it pop up in the chat and I was like, I don't. I have invoked fair use for the Sanborn maps that are still under copyright. Yes, I know that, okay, so Sanborn is long gone out of business. Somebody bought them up and now somebody licenses out Sanborn maps. What we've digitized is important to local history. What we've digitized is, you know, what we had in our collection. It's a small portion of what they offer for license. So I have not sought permission. I have put the right statement in copyright and I've gone ahead and put them up. And, you know, if somebody gives us a takedown, you know, we'll proceed. But I have not yet contacted them with any kind of permission.
Okay.
request.
Do you have any recommended templates or wording you use when you contact people about copyright?
I think the best thing to do is to just be, you want to write a good letter. What is your project like? Include some details. Um, how will this benefit the population that you're trying to benefit? Can be, you know, why is this important to the project? You know, especially when you're dealing with an individual who doesn't normally deal with permissions. If you're dealing with a licensing association, you know, it's just straight up and down, you know, you have to give them the information they ask for. But, you know, write a good letter. And I don't think there's anything wrong, you know, with pursuing them. Pursue them once or twice. Sometimes the person is just like, I don't want to answer this, or I don't know how to answer it. Other times when you touch base with them the second time around, they'll be like, yeah, I can give permission. Sometimes they don't know if they own it. We had somebody come and talk to us about copyright several years ago at Kent State. They asked, he was asked, you know, are you going to put your book up on Google Books to, you know, be read by everybody? And he said, I don't remember what my contract says and I can't find it. And I'm a copyright expert and I don't know the status. So I think sometimes it does help to talk to the person. But yeah, and then just keep those records, keep the emails, you know, keep email counts. I try to get things in writing. I try not to do too much verbal stuff.
We did
And
have a couple phone call permissions, right? But we wanted to get either email trail, or some people would do snail mail the responses too.
remember that whatever permission you get from the copyright owner, that's for that one project. It's not for every subsequent project. It's per project. So I think John Philo, people like him must get so sick of, oh, can we use your picture? Can we use your picture? Can you use your, it must make them crazy, but you know, so
Yeah.
sometimes they
And
don't answer us.
we had, I think, what, 4 of us working on copyright permissions for NHPRC. And I know for me, I tried not to use what would feel like a template because I wanted it to be a little bit more personal, especially for the non-corporate requests. So I try to make it seem like it's a, a real person and not just spam.
Okay, last question, unless anybody has a last minute thing they want to throw in the chat. Who contacts people about copyright? Is it the 2 of you, or do you let students try as well?
Been us. We have not had students do that kind of work, have we? I don't think we have.
Not
It's
copyright.
mostly,
Yeah.
yeah, it's mostly been us on staff. We don't even have them do a lot of Sanborn searching. I mean, they can look for the copyright statement on the Sanborn map and indicate if it was there, but to have them contact people, I think it would have to be like a really special student, the grad student who was really interested. If I had like a law student or a lawyer who was going to library school, I would let them do it.
Yeah, I think when we started the grant, we had originally written Cindy into doing all of the copyright review until we realized like this is far more than one person. So Cindy trained myself. We had a digital project specialist assistant, and then our special collections. I can't remember Haley's title, digital initiatives and outreach librarian, but it was all full-time staff.
She's taken the Copyright X. I mean, she was into it. She took the Copyright X course and everything because she likes it as much as I do. Maybe not as much.
Okay, that's all the questions we had. Regina, if you want to move to close.
Hi, everyone. Well, thank you, Cindy and Virginia, for the wonderful presentations. I'm sure everyone learned, I know we all learned a lot about copyright in libraries and copyright in general. And we certainly thank you both for taking the time to share your expertise with us. And we really do appreciate it. And I'm sure all of our members appreciate it as well. And the link for the presentation and the recording, the PowerPoints and electronic evaluations will be emailed to all of our members. We sincerely look forward to your opinions and ideas on how to make our meetings more useful and enjoyable. So please take a few minutes to fill out and let us know how we did. Also be sure to let us know, fill out the evaluations, I'm sorry, and let us know how we did. So also be sure to let us know if you might be interested in serving on the board. And if you have any topics that you might be interested in. So thank you, everyone. Be safe. And we hope to see you again in the fall. And this concludes or adjourns our spring 2021 NOTSL meeting. Thank you. Bye-bye now.
Do we need